मैं प्लीज चलो से
was 24 to
my lord. मैं प्लीज चलो से I
Yes.
think मैं item 10 lordship
10.
I beg to mention item number 3, Lordship.
3. Wait for it to come.
The other side, I beg to Lordship, we need further time.
Suppose it if he is see when the matter reaches. Yes.
May I please, your Lordship? Lordship, we consent on other side, item number 13.
13-1-3.
In this matter, we need to file the affidavit,
right my lord as the last chance Antit my lord to file our affidavit.
If it let the matter reach, will we are not disturbing, we are not harming any case.
Lordship.
Your Lordship. Lordship.
33.
Receive any instructions, Your Lordship. File a affidavit, Your Lordship.
Has been made by the learned instructions and would require
2 weeks time, Your Lordship.
Interim order, but that will be continued.
interim order.
Much obliged, Lordship. I beg to mention order 43 with 44, madam.
Oh.
On earlier occasion, Lordship, instruction. We have not yet received out of station. To adjourn only for
Matter we have to take and the matter is there with us. Yes.
And so the petitioner is already full.
The grievance raised in the closed.
Lord, engaged my lord for the petitioners in 1 and 2. It's wrongly listed as stay vacating. There is in fact no stay vacating IA. There is an IA filed by the petitioner which is pending. I've taken the consent of my learned records led by Mr. S. Datta. 3 weeks.
The agreed petitioner has
Sharma.
Accordingly, list this matter. Application is not
Is basically it's in prayer for not to take the coercive action against the bank action.
It's an
The
IA,
bank.
no, it's an IA for an
We have
interim
taken-
order and there is an existing interim order.
Yes. There is an interim order. We have taken the surface.
first column.
Lordship, I'm appearing for respondent number 2.
Your
Interim order may
Lordship,
continue.
this matter may be come
First
up for the
interpretation
admission,
of-
I think, Your Lordship. This matter may be come up for the admission.
There is an IA.
Is decided, it comes up in the order.
Deeply.
Date may be fixed, Your Lordship, in this
Sorry?
matter. Date may be fixed.
Pablo.
Oh,
Yes.
Totally good.
MP.
in the present form. Prayer made is not object.
Yeah, please, Your Lordship. Your Lordship, Mr. S. Your Lordship,
Yes, what is it?
Mr. S. Roy was supposed to obtain instruction
Ah.
regarding the allotment of the fifth shop, Your Lordship. Yes, yes, that has been already allowed, amended. Now, out of 5 shop, 4 has already been allotted, and regarding fifth instruction was supposed to be. But
Says if the legal aid of the petitioners
yes, it is long, there is in February, instruction is of
be
If-
applied.
Your Lordship. On last occasion, it was listed on August, but that instruction was not there.
Will punish them for not producing.
I will make
Tell
an
us whether you want to file that substitution application.
already allowed.
The concerned authorities that please our names for my
Yes, yes,
father and allow us to continue. They have
that can be
allow
done.
you.
That can be done.
We'll close the writ petition.
Let it kept pending. I will make an application. It doesn't consider.
Do you have your legal aid certificate?
Yes, everything is there.
The clients when they can have
Let it come after vacation, Your Lordship.
ask your
NOC and legal aid.
certificate and when. Then we will take your applications, they will come. Allot you, we close the
yes.
writ petition. If they don't,
Your Lordship. Your Lordship, get a- yeah. Oh,
Legal air certificate.
yes, that is there. After submission of my legal aid certificate, they have allotted another 2 shops, Your Lordship. Legal aid.
Last shop also you need to apply.
Yes, I'll make
An
an
application.
application.
It has just before this court action dated 6th by contains the letter dated 5/2/20. It's that the legal heir of the original allottee submits application for succession along with necessary and NOC to the allotment of shops valid and continue. R. Mazumdar, Learned Counsel. Allow the petitioners to submit the and revert back with the decision by the municipal board, full stop. On which date the Learned Counsel for the petitioner shall the steps taken. Yes.
It is, madam, we are assailing here a recovery order passed by the state officer, the Public Premises Act, while holding his proceeding at Calcutta in respect of a property situated at Panbajar, Guwahati. Now, whether he has the jurisdiction to do that, only question, my lord. Now, kindly see the first order. My lord, they have appeared, my lord, they have filed their
I have filed my
affidavit.
affidavit.
It may be posted for admission hearing any day, my lord. Take some time, that's why I'm saying, my lord. It appears to be the list is little long, that's why I'm saying, my lord. Hearing day, Tuesday, Thursday, any day, man.
My lord, what happened? First of all, yes. First of all, that my defense is that whether they have the petitioner says the locus standi. Because the state officer proceeded notice gone against the company, company. And the individuals are now representing. Second objection is that, my lord, under section 3, notification was issued by the Ministry of Finance, providing allotting the jurisdiction. The state officer sitting at Calcutta can do, Ministry of Finance, Government of India. And LIC is a corporation under the Article 12. And the
So you want to say.
Ministry of Finance circular is
Like
applicable.
the jurisdiction of courts, but
But yes, he can preside there also sitting. Exactly. Yes, another date may be taken in.
the pleadings are complete.
Yes, pleading is second.
May be taken up for. Stop.
Any day, my lord. Even this Thursday, I'm ready. Any day that is convenient, your lordship.
May be taken up in the. Day?
Any day, kindly fix the date, my lord. Yes, yes, that will do.
Of December, I think.
Second of December, yes. Materialized.
Lordships, I'm paying for my lord further
Yes.
3 weeks, Lordship.
The affidavit.
Lordship, everything now. 148 proceeding, Lordship, reopening of assessment, my lord, under section 147, my lord.
The
2 and
respondent-
3, Lordship.
Notice that the matter is the
Let it be 2 weeks, my lord. Let it be 2 weeks, Lord.
Time is there also.
Deeply obliged, my lord.
Oblige Lordship. In this case, let's say,
something you can demolish the whole. Not demolish the whole building.
Demolish means they should provide us they say that this building has constructed on 1973.
Ah.
And nothing has been provided to us. That's the difficulty, my lord.
From 1973, department has no record of that building.
They say that in 1973, but they have communicated that they please provide that the NOC. Nobody is providing that. Neither the respondent, nor that particular building. They claim it is it has been constructed. We are getting an NOC of 1973. Nobody is showing, neither the respondent, neither the petitioner. That's the crux of the matter.
Have you? For 5 and 6. You have filed your
No, I have
affidavit.
no problem. Private respondent, my lord.
sellers.
Stop.
I'll also file my affidavit.
Filing or you have filed?
I will be filing. I have not filed.
With file.
It's a private respondent that
Respondents have already filed.
private respondent that filed. 1 and 2.
Yes.
On behalf of respondent.
Told him the building and the land. Did you not?
On behalf of the council, my lord.
Yes.
I'll
3
inform,
weeks.
I'll inform the.
3 weeks, the NOC, if it comes on record,
They are the owner, my lord. They should have it, my lord.
Who?
They are the owner. Petitioner are the
They.
owner.
when
Lordship.
I'll inform them.
May it please, my lord. There's
Yes,
a
sir.
connected IA, my lord. Perhaps that has to be disposed of first, my lord.
Who's that IA?
One of the petitioners expired, my lord.
Huh.
Cause of action still survives, my lord. This is an application for substitution filed by the
Yes,
daughter.
Union of India, any
Lordship,
objection?
in this case, Lordship, petitioners claiming that his one portion of his building also acquired by the NHIDCL. And Lordship, I have filed one affidavit, Lordship, that now that land is not required, Lordship. Now road is already completed, Lordship.
In any case, it has
So
to be
matter-
disposed of, my lord, before it is.
In Lordship. Yes, yes. Lordship. Lordship.
My lord. Daughter of the two.
That. Be allowed. Of the present. Is accordingly. So now come to the. Has been allowed to substitute. Is this matter again on?
Present.
Lordship, can it be on 6th, Lordship? Eighth of December.
December.
8th of December, Lordship. 8th of December.
And which was in
Already work has been completed. Appeal, your lordship. Appeal the service of the credit card facility, no respond to lordship.
Sorry?
Appeal the service of the credit. One also file. How to file affidavit and lordship.
I'm for the State Bank of India, my lord. Respond number one, my lord. Our submission is that the State Bank of India and SBI credit card are different entities, my lord. State Bank of India is formed under the 1955 Act, my lord, and it formed, it's a company's act, my lord. It's formed different entities, my lord.
In the umbrella lordship. Under the SBI
My
lordship.
lord,
There
They're
has to
different
be some
entities.
reason they use your name. There has to be some connection.
different entities, my lord. Lordship.
Article 12, it becomes. Did not. That name. That I am a credit card of that bank.
Right, my lord.
Of that ground, then we are going to Bank of India and the State Bank of India. Of India, that of law governing who can use.
Lordship is a joint venture between SBI and GE Capital Lordship.
You have not filed your reply.
Yes, lordship, I may be allowed to file affidavit reply, lord.
Number 3, who is respondent number 3? It's the order dated. File his affidavit. This matter be listed after. File their response filed by the filed on 20. Yes.
Ali Ablas.
Yes, sir.
In fact, covered by coordinate decision of this one.
That is where we raise objection.
Objection they are raising, I will.
That is, they supposed to file a license agreement. That not yet filed.
Filed, but it is not on record.
I also have not received copy.
Some may be defects because of that.
Agreement. By way of an additional. Number. All the. May make his to be filed in the matter is
It on the hearing day, my lord, because second, your lordship, second December.
Except 8.
11, 12, my lordship. Both are connected, my lord. 11 and 12. Deeply obliged.
yes.
Your Lordship, I'm appearing on behalf of respondent number 4 on behalf of my sir, R. Baisha.
Four.
Yeah,
Who is he?
Narinan Chowdhury.
Private respondent in this case, Lordship.
Your Lordship, in this
Lordship, we have. One direct.
What?
Corruption, Lordship.
Alleged corruption of
Election, Lordship, regarding.
Your Lordship, we need more time to file the affidavit in opposition.
okay, learned counsel.
One on.
Say Sylvan 3. Is related to
Your Lordship, in this matter, the state read earlier on number of occasions for filing. Last date was, Your Lordship, 21/6/23. After that, Your Lordship, matter has been listed today.
up on Friday.
Have not filed as yet the with Your Lordship in response. I have a humble prayer, Your Lordship, the matter may be fixed in the next week for admission hearing and it can be disposed of. It's a land acquisition matter, Your Lordship. A big vast area of land, Your Lordship, they have taken forcibly. Position, Your Lordship, without there being any acquisition,
wanted to be
without
listed-
there being any compensation.
with or without their affidavit will hear that day on the facts also.
That's,
Yes, what do you say?
that can be disposed.
Try to obtain the instruction.
To N is
That's it.
comma.
Without compensation, anything.
Till date. Or
There were.
That's the 10th.
There I have not heard.
Okay.
Sorry, yeah.
None appears for the petitioner on call. Therefore, the petitioner. You are appearing for whom?
Well, we are not party here, my lord.
Why are you appearing?
No, earlier we can appear, my lord. Now there is a standing council of soil conservation.
The party is on call. It's them to bring on an advocate, not. On 1st of December 20. There. Parents, yes.
Amy Mundal. Short date may be given to file our reply.
You are for the.
Appearing on behalf of Mr. Yes, my lord, I am appearing for the petitioner. Respondent number 6 have filed in. If we allowed some more date to.
Object then.
What can be done? We have filed our affidavit in 2023. Object lordship, that is. We have waited for.
Affidavit say.
Lordships. Paragraph 4 lordship we have stated that it's a government first land lordship which they are occupying. Eviction notices were also issued upon them lordship.
No, I will file a reply affidavit, my lord.
Comma. The feasibility. Since the last. Dated 19. Possession of the petitioner in respect. Been continued. Six full stop. Learned Council appearing.
Okay.
Non-payment of contractor's bill, my lord. Page 20, your lordship, this is an admitted,
Will be admitted.
admitted, my lord. Page 20, your lordship comes. The reply to that notice, they have admitted the amount.
Yes, water resources. Who appears water resources? Standing Council Water Resources, the heredity. Notice will you can.
Non-payment of non-payment of contractual amount, my lord.
Lordship,
Where occasion they have taken.
Lordship, admitted or not, that I am not aware. Lordship, so far as instruction is concerned, that is awaited, Lordship. Lordship, it is a case of 2012 work order, so it is taking some time, Lordship. Lordship, I am praying for only 3 weeks' time, Lordship. In the meantime, whatever, if it is there, I
Additional Advocate General appearing for the respondents has submitted. Full stop.
Can I pray that, my lord? Can I pray that, my lord?
Take you to near that.
Fine. Yes. Yes.
But here in file. Exactly, sir, and in their, in our contention is that try to evict us by issuing notice all. That part they have not denied. Respect to Patta land, they have not denied. That means it is admitted that it is our Patta land. Now with respect to the another, that they have specifically stated that the exact boundary of reserve forest could not be ascertained during survey of the forest. In the Rongjuli and Dosholai, Athayabari, Ghagra, Goalpara district.
Palpara. Yes, sir, some
Lordship may
Going on,
kindly come to our paragraph 6 of the affidavit filed by the respondent number 7. 7. The circle officer, Lordship. Page number 95.
corrected. Respondent number. One.
Pritam Raja, sir.
Your index says 94. Court is.
Lordship, I'm
and
sorry.
94 is actually number 4.
This is Pritam Sharma's affidavit, Lordship.
Sharma.
Almost same affidavit.
Paragraph 6. The last part has your
Not be sir.
yes, could not be ascertained during survey which has been ascertained by Forest Department. So, Lordship, it is not like that we are not disputing his patta land, Lordship. When the boundary is ascertained, Lordship, maybe he's there or outside. In case of inside, Lordship, he will be evicted, otherwise not. That has not yet been ascertained by the forest department. The forest council will be required most likely. Lordship. Yes, yes.
And kindly see the paragraph 3 also. With regard to statement made in paragraph 1 and 2 of the writ petition,
Forest has filed any,
opponent
who has
has
given the notice? Issued by?
issued by the forest.
Forest department, they will be required, Lordship.
You are appearing for the forest department. Yes, what do you say? Forest land. You will not identify the land and you will throw out any. Is that notice? That notice?
Notice, my lord,
What are you challenging?
Annexure 2.
Which?
57.
Huh?
57.
Wrong with this? Anybody who is in the forest land,
To evict us, our land. They cannot, but they tried to evict us from our land. And this notice, kindly see page 58, how this notice has been issued, my.
did not. No,
We have produced all the with respect to
that
the
we will do it before the authorities. We are not.
circle officer, on the other hand, did not deny that it is not a authenticated.
Or it may be.
Post reserved
Without
RPL.
and if some what had happened,
And
we'll look into that aspect.
and all this. And all the petitioners are indigenous persons.
If you have, that would have very little effect whether they are indigenous. Holding a piece of land.
Forest land. Yes.
Have your instructions on Thursday.
There was an interim order.
Please, Your Lordship, on the last for short time to
You appear for?
appear for the petitioner, Your Lordship. Respondent short time to file.
Yes, sir. Has it been filed?
Has been filed, long back, man.
Then can it be on 8th or 9th of December?
Respondent number 2, filed by respondent number 2.
Filed by respondent number 2. Do you have a copy, sir?
Yes, Your Lordship. That was on 2024, Your Lordship. But on the last date, as the observation was made that 22/7/2020.
Or 1, 3, and 4, sir? Who has filed?
Who
Is it
has
on
filed?
behalf of everybody? Want to file anything? Affidavit. For assisting the scene.
Affidavit not yet filed.
The respondent number 2, and therefore Learned respondent number 2 to this matter again after history.
Can it be on 8th or 9th of Can it be on the month of
January 7th of January. You've seen the calendar. By which time? All completion of plead.
into front?
Please, Your Lordship. My lord, the issue here is very small. All the petitioner contains 115 pages. 50 pages, but the issue is very small. The government has issued notification, the revenue department, regarding fixation of land value. Assam. It has been done properly. There's no issue. But so far, the lumping is concerned, Marin Hujai, my lord. While doing that, page number, Lordship, kindly see, page number 76, my lord, kindly see. They have not followed that, my lord. Guidelines. Guidelines is page number 32. 32 is the guidelines. Dated 16th of September 2009. Revised guidelines for fixation of zonal valuation of land in the state of Assam. My lord, these are the ABCD, my lord. But there is no problem about this, my lord. So, you may please come to page number 76. Let me read this one. This is in respect of, I'll show, in respect of Hujai, Lanka, Lamding, those part, my lord. Dated 16/12/21, in pursuance of the government letter by number such and such, dated 29/12/01/21, and as per recommendation of the land district such and such, under Lanka, Hujai, my lord, published on 29/21. Lordship has seen this, my lord? Now kindly see the second line. What's the date? 29/12/21. Now come to the, my lord, in the third, fourth line, 29/21. See, on 29/21, can there be any decision on 29/12 in my lord, in future, my lord? This is what they have mistake. And it is also written there. The claim and objections were again placed before District Land Evaluation Committee. Now please come to page number 115. Yes,
It is 6921.
that is in page number 74. That guidelines, my lord, page 32, same guidelines. Second time government has issued the guidelines. So they are supposed to follow this one, my lord. And kindly see this page 76 notification. It says, after due considerations of claims and objections, the district's valuation committee, which has finalized the land valuation and accordingly notified such and such. This order will come into force with effect from 1st January 22 to 31st December 23. So it has lapsed. Now my submission is, Lordship will kindly direct the Deputy Commissioner from now onwards, because next notification valuation has not been done. If they do it, let them follow this page 32 and page 76, that guidelines government, my lord. This is the only issue. I think there cannot, no objection should be there.
Lordship, what is their prayer, Lordship?
Guidelines of the let government guide, let them follow government guidelines and dispose this of matter, my lord.
The Premier say it is most respectfully prayed that your Lordship should be pleased to admit this petition called, has your Lordship got it? To notices upon the respondents to so cause, if any, as to why the read in nature of such a mandamus and or any other or to quash and setting aside the zonal land valuation of Hosai revenue circle of the Hosai district by the government of Assam in the prepare an uniform class of land for all the revenue circles in the district. Revisit and issue a fresh land valuation in respect of the land, all the three revenue circles of the Hosai district by providing due opportunity of hearing to the public and after hearing the parties and on perusal of the records. All these things were done, Lordship, which is reflected in this notification itself and in our affidavit.
I'll show if yes, no.
Let him complete.
Okay. Now, just let me one sentence. If there is a little longer argument, I can show the details what the mistake are the things. I am not going on this. I say that's what.
And Lordship, in our affidavit filed by, again, Lordship, maybe the page number may be mismatched. It is filed by the respondent number 3, Joy Shankar Sharma.
That's at 116 for me.
Yes. Now, yes, Lordship. Now, next page, 117, paragraph 4. With regard statements made in paragraph so and so, your deponent respectfully states that as per the government instructions, draft zonal value of the land under Hosai districts were prepared by the circle officer Hosai, Lanka and Doboka Revenue Circle, and same was published hung on the notice boards of the office of the concerned circle officers under Hosai district as to the file any claim and objections if any person. After publication of the draft zonal value in the notice board, a few persons raised their verbal objections before the concerned circle officers, but no written objections was received within stipulated time by the district level so and so Hosai. However, after due consideration of the verbal claims and objections and as per the government approval, the final notification of the zonal value was published. This part has already complete, Lordship. In future, Lordship, in case any that undoubtedly, Lordship, these things will
Whatever
be.
was there.
Lapsed. And I filed petition in 22. On the pendency of the case, it has lapsed. So I said, when next they go ahead with this one, let them follow the guidelines. That's all, nothing else.
Guidelines, they will
These
follow,
are the guidelines.
Lordship. For the-
32, 76 are the guidelines.
There was this just observe that
Observation, that's all, nothing else.
uh,
But Lordship, I'm sorry for the interruption, Lordship. Not only the department will not confine to this notification. Any further notification may come, Lordship.
No objection.
on a number so and so. The prayer meets Mr. Nath, the learned senior counsel appearing petitioner has the learned counsel this writ petition. Are no longer now failing. Applications full stop. Submit that no apprehension that the making further valuation regarding category of land. Valuation or categorized.
One sentence, if your lordship said, my lord, just little word notification so that the public may know it, so that. Suppose the government wants to do this again now. Officially secret, they do it, just a wide notification or some, so that people will know and then come forward, that's all. It's a, I think it's enough, my lord.
Allow for public notification prior to such categorization and valuation. Huh? তিনখন যে ৰাখিছে যে
Are in effect cross appeals. But 23, which the ombudsman, whereby we had been directed to grant new electricity connection to the respondents, notwithstanding outstanding liabilities that were due from the previous owner of the property. And the second petition, item number 22, was filed by the respondents. There they are the petitioner. They are saying that they should be granted the. Perhaps if your lordship hears the council has graciously
start with him.
So, lordship, I'll start with, in fact, lordship, what I'll do, and in fact, since 22 was the lead matter, I had prepared my notes from the item number 22 itself. Lordship may have that brief, item number 22, but I'll, because the annexures are the same.
Stop making us juggling the matters.
I'm really sorry. Annexures are the same, your lordship.
22.
22.
Yes.
So I'll just I'll just give your lordship the facts in a nutshell. There was this group of companies called the Brahmaputra Group. They had business, etc. They were electricity consumers of the APDCL. So they had outstanding liabilities. But in the meantime, proceedings were initiated against them under the SARFAESI Act. So those companies were, then their properties were taken over by the banks and then sold. The respondent is one of the purchasers of those properties. Now they wanted to develop that property. So because of those outstanding liabilities we had disconnected, they applied for a fresh connection. We refused. We have said that since there are outstanding dues, as per the Electricity Act and the rules framed thereunder, we cannot grant you a fresh connection till those dues are cleared. Against that, they went before the Consumer Grievance Redressal Forum. It's a statutory forum created by the AERC. That we should be granted a electricity connection. Consumer Forum said that no, you have to first clear the outstanding dues, and only after the dues are cleared will you be given the connection. They challenged their order before the Ombudsman. The Ombudsman held in their favor, said that no, because of certain reasons, which I'll show before a lot. The dues of the previous owner cannot be fostered on the subsequent purchaser, and he has to be granted the electricity connection because that is an essential commodity. And they also relied upon Section 56 of the Electricity Act, which says dues which are not recovered or not shown as recoverable beyond a period of 2 years, then they cannot be made recoverable later. Those are the parameters of the present matter. If your lordship has my affidavit in opposition, it's the same as the petition. The annexures are the same. If your lordship has page number 203 of my affidavit in opposition. This is an agreement for supply of electricities between the former Brahmaputra TMT Bars Private Limited and the Assam State Electricity Board. There your lordship will see clause number 2 at page number 204. Amongst other clauses, one of the important clauses is the consumer undertakes to comply with the requirements of the Indian Electricity Act 1910, the Electricity Supply Act 1948, the Indian Electricity Rules 1956, the terms and conditions of supply and schedule of tariff of the Assam State Electricity Board, and Indian Electricity Act 2003 and the rules made thereunder. The schedule of the property where the electricity is to be provided, that your lordship will find at page number 205.
I will disturb my learned friend. My friend is going into the issues are there mainly. We also agree. One is that whether the surcharge which has been levied can be levied or not.
Yes.
That's the legal issue first. Second, whether the fixed charges beyond 6 months can be levied or not. Are the two issues. Whether it can be levied on me or not, I am not saying that it cannot be recovered. It can be recovered, but what is legitimately due. So if these two issues, the Ombudsman has said, I will not disturb you, that the surcharge is not leviable because the amendment was made in 2017, and for the period prior to 2017, the surcharge cannot be levied. That is the finding of the Ombudsman. And the fixed charges, it has said that as per the Act itself, tariff itself, it is for 6 months disconnection, permanent disconnection. So beyond that, it cannot be levied. So my lord, according to me, to certain only, I am not disturbing my lord him, that the issue whether the agreement was there or not, these are not disputed at all. The two issues are there, whether surcharge can be levied or not, whether fixed charge can be levied or not. And if this can be decided either in my favor on them, then the matter ends.
Why? A situation has arisen where the original owner of the property, he consented to acts to be done. He said that, for example, give us a relaxation in the date of permanent disconnection beyond 6 months of the temporary disconnection. It was at his multiples request that this was done. So why I am taking your lordship to these documents is once this was done at his request, and then the original owner has got the benefit of that extension. Can the subsequent purchaser come and say that merely because according to them, this is not permissible, so I will not pay? This was considered by the ombudsman, and in my humble opinion, wrong.
We will.
Because it was, your lordship is otherwise into 26 jurisdiction. This observation of the ombudsman is prima facie bad in law because it has proceeded on a wrong assumption of the present legal position of the.
Okay, show us what.
Very well. So if your lordship has the schedule at page number 205, lordship will kindly take a note of the DAG number and the patta number, which is item number 2.
That is not in dispute at all.
That is not in dispute, but very well. Then your lordship will see page number 207. That is the crux of the dispute with the original owner. The letter of 22/2011. With reference to the above, I'd like to inform you that as per regulation 2.2 of the terms and conditions of supply 2007, notified by AERC, the normal supply voltage for connected load above 5000 kVA is 132 kV. As your present connected load of 11076 kilowatt far exceeds the above requirement, you are therefore requested to make arrangements for conversion of your supply voltage from 33 kV to 133 kV at the earliest. So what this basically means is that if your consumption is beyond a certain limit, you need to convert your supply to 132 kV. If that is not done, there is a conversion loss, which the distribution company has to bear. So basically, we requested that your consumption is much beyond that limit, so kindly get your connection transferred to a HT connection. Then your lordship will have page number 208. Because this was not done, at 208, we wrote to Brahmaputra TMT bars. With reference to the above, I'd like to inform you that vide the aforementioned letter for conversion of your supply voltage from 33 kV to 132 kV, as your connected load exceeded 5000 kVA. However, as you are still drawing power at a lower voltage than specified by clause 2.2 of the AERC terms and conditions, you are required to compensate for the loss at the rate of 3% of energy consumption. This is the LTMU loss. There, your lordship will see, because they did not pay, an order was passed on 31/7/2013 at page number 211. That LTMU
% of the energy,
yes,
total energy that they consume, they have to pay 3% more.
page number 211. This is the first request for them to pay an outstanding amount of 1 crore.
111 is
A letter of 31/7/2013.
the request to disconnect.
Yes, because of outstanding dues. Basically, your lordship, what happens in the system?
And thus, it is written area manager.
Yes. So
the other area manager.
yes. So the process of disconnection is such that first there is a temporary disconnection, then a request to pay. If that is not done, then there is a permanent disconnection. So this was the first communication.
Temporary.
Temporary. That was for outstanding dues at that. I'm coming to that.
All the outstanding
For all the outstanding dues
of everything.
Yes.
3% and
Yes.
also what?
No. I'm just coming to what I'm saying, your lordship, is the outstanding dues on 31/7/2013 of the company was 188,24933. That
This includes what?
This includes the outstanding dues. At that stage, the LTMU charges had not been calculated. Why I had showed the communication to is because later on, because these charges were not, the facts are a little. He was not even paying that also.
And he was not paying the
LTMU also. The LTMU had not yet been
3%.
calculated at that stage. We had requested him that if you do not do this,
only the
And not paid on actual consumption.
Actual consumption. This amount reflects that. Yes. Then on one to 2014, that is your lordship will find at page number 212.
This includes everything.
No, at this stage also it's not been, this only includes the consumption till this stage. On 1/2/2014, with reference to the subject cited above, you are requested to permanently disconnect a service connection of the above mentioned consumer. TDC of the consumer was done. TDC is temporary disconnection, was done on 31/7/2013, and 6 months energy bill will also serve to the consumer up to 31/1/2014. The consumer has failed to clear the outstanding dues. You are therefore requested to permanently disconnect the line and bring back the board's materials after proper assessment at the site after disconnection. The consumer will not clear the bill amount as on 17/2/2014. This last bill due date.
Now you had given month's bill
Yes,
of 6 months.
because what happens is that a perception that the officers had was that the maximum period of disconnection could only be 6 months. It cannot travel beyond that, and therefore at 6 months you are supposed to permanently disconnect the line. The reason for original temporary disconnection is not removed. Here it was payment of outstanding dues. Since that amount remained outstanding, the officer, this area manager IRCA 2 wrote to the subdivision engineer saying that it should be permanently disconnected. Page number 212. Now, on page number 213, your lordship, when we tried to permanently disconnect the electricity connection, clause 3, your lordship. Copy 2, yes, your lordship. This is for your information that their power supply to your premises was disconnected on 31/7/2014.
1 to 2014.
Your lordship, that is a typographical error. It is 31/7/2013. 31/7/2013. If your lordship has the letter at page number 211, it's referring to that. Temporary disconnection, 31.
Yes, okay, 2000. Then
your lordship will see on 26/3/2014 at page number 213, there is a request for deferment by the original owner. It was not done.
it was not done.
On 26/3/2014, the former owner writes to the general manager saying that with reference to the above, we'd like to request you to extend the time of permanent disconnection of our unit as it was already extended up to 31st March 2014. As we are passing through a great financial hardship, we are not in position to pay your dues on time. We would therefore like to request you to allow us 3 months time, and today we'll pay rupees 50 lakhs against our area dues of the said unit. This is our earnest request to allow time to pay the remaining balance amount at a later date and extend time as we prayed for. Lordship has page number 214. Yes. I am directed to inform you that as per your request, the permanent disconnection of Messrs. So and so is deferred by 3 months up to 30th June 2014 with the condition that you have to pay rupees 90 lakhs per month during this period to liquidate outstanding. In case of failure to make payment as above, the service connection will be permanently disconnected, and the load security amount will be adjusted against your revenue dues.
I understand that they were given
Yes,
Have a list of
yes.
the just made and the
In fact, they were-
thereafter what happened?
then they were given multiple opportunities. Then your lordship will find 215. Again, they deposited a check of 1 crore on 36/2014,
Bounced, then
which bounced. Then your lordship will find at page number 219, there was another request from them in the meantime on 1/8/2014 for again deferring the. On 31/8/2014, before the sale, there was a public notice from APDCL that it is gathered that the above consumers are intending to transfer their properties, land, building, etc. through sale, lease, etc. without clearing the dues of APDCL. Prospective purchasers stroke lessees of the said property situated in village so and so is requested to satisfy themselves about the clearing of the outstanding dues to APDCL by the company before taking over the possession of the said properties. In the event of non-discharge of liabilities by the aforesaid companies, the purchasers stroke lessees will be liable to clear the up-to-date dues to APDCL before power supply is restored provided to them as per sections so and so of the Electricity Supply Code and related matters 2004, First Amendment of 2007. Then your lordship will see at 15/9/2000 on 15/9/2014 at page number 221. A final notice was provided for permanent disconnection, and on 30/10/2014, lordship will have that date at page number 222. The electricity was finally permanently disconnected. On 1/7/2016, your lordship. Yes,
Where do we find it?
that your lordship will find at page number 227. The SBI, your lordship, which is the bank initiating service proceedings, writes to the APDCL. Lordship will have that communication at page number 227. The Brahmaputra group of companies was sanctioned. Yes. The company makes default of electricity bill. Accordingly, the electricity line was disconnected by the electrical department in 2016. Why I am showing this communication to your lordship is that the creditor, the bank which had initiated the SARFAESI proceedings, even they were aware that they were pending outstanding dues on the property. Now, this is the document I am going to show your lordship is where the dispute arises at page number 228. 228. This is a report of the Comptroller and Auditor General of India. Lordship will recollect the letter which I had shown your lordship of the year 2011 regarding the LTMU loss. So that was communicated, but that was never made a part of the outstanding dues which were made payable by the Brahmaputra Group. So an audit was done by the Comptroller and Auditor General, and this is the relevant portion of the report. Lordship will have 3.2 at page number 229. If I may read. As per clause 2.2 of the Electricity Supply Code and Related Matters Regulations 2004, First Amendment 2007, Lordship will kindly have a note of this supply code because there a mistake has been done by the CGRF and the Ombudsman. Notified by the AERC, the voltage of supply to consumers shall be determined on the basis of the contract demand of the consumer. Any consumer having a minimum contract demand of 5 MVA was to be supplied electricity by the distribution licensee at the voltage level of 132/220 kV. Examination of records of the company revealed that the company as a temporary arrangement allowed one consumer, Mr. So-and-so, to draw power at 33/132 kV voltage level for 6 months up to 26 April 2011 as against the prescribed level of 132/220 kV. To facilitate the supply at prescribed level of 132/220 kV voltage, the consumer is directed to construct the required infrastructure at their own cost within the period of 6 months. Similarly, the company also allowed another consumer, we are not concerned. It was, however, observed that the consumers did not create the necessary infrastructure to facilitate the company to supply power at the voltage level of 132/220 kV. The company, however, even after the expiry of the stipulated periods, continued to supply power to both the consumers at 33/132 kV voltage level in violation of Regulation 2.2 of the AERC code. It may be stated that during the process of transformation of electricity from a higher voltage level to a lower voltage level, there is an inherent transformation loss. This is corroborated by the fact that as per the electricity tariff of the company, as approved by the ARC, for supply at voltages higher than as applicable to consumers, as regulation 2.2 of the ARC, rebate at the rate of 3% shall be applicable on energy consumption for each higher level of voltage. Apparently, the rebate of 3% was extended to the consumers in consideration of the potential savings in the energy loss for supply of electricity at higher level than prescribed. Thus, the company, by supplying electricity to both the consumers at the lower level, then specified by AERC, had incurred energy loss in the form of transformation and line losses. In absence of any stipulation in this regard in the ARC regulations, yes. Now, your lordship, yes.
Yes, then what happened?
Another public notice was issued by APDCL, your lordship, on 1/9/2017. That your lordship will find at page number 236. There, the outstanding dues of all the companies amounting to 10,83,000, 10 crores 83,48,900. That was published in the newspaper. At page number 232, your lordship, the APDCL wrote to the authorized officer under the SARFAESI Act of the bank. With reference to the above, it is understood that so-and-so is going to sell the assets of Messrs. Brahmaputra Group of Industries having units, namely so-and-so, 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 through e-auction. In this regard, it is to mention that the Brahmaputra Group of Companies has an outstanding amount of rupees so-and-so only up to February 2017, likely to increase as days pass, as electricity dues against APDCL in IRCA 2, Jalukbari, Guwahati 2012. I request you to kindly look into the matter and do the needful so that outstanding amount is recovered and paid to APDCL. Now, your lordship, the property was sold to the respondents, not through an auction, but through a private arrangement. I think they did not find, the bank did not find anybody willing to buy the property during when private arrangement. It was finally sold to the. That is not disputed. So lordship will kindly have the certificate of sale. It starts at page number 253. Page number 253, the certificate of sale.
Okay, it was sold then.
Yes, your lordship will kindly see the description of the property at page number 244. I'll not take your lordship to the entire thing, just one sentence. 244. Description of the immovable property as is, where is basis. Brackets. Lordship will kindly take a note of that. I will come back to this, your lordship. Now, lordship will find communication of 9/9/2021 at page number 256. This is from where the dispute starts with the respondent. To Shri So-and-so, HK Sagar Industrial Park, with reference to the above, please find enclosed here the statement of outstanding data against Messrs. So-and-so on this connection. It is to also inform you that the surcharge waiver scheme is reintroduced by letter number so-and-so. You are requested to grab the opportunity to clear all the old outstanding dues as mentioned above. Outstanding data against Messrs. Brahmaputra Group of Industries, surcharge waiver scheme of 2021 and surcharge waiver form. Since we have claimed the outstanding dues of the previous owner, they go before the Consumer Grievance Redressal Forum, the body created by the ARC, where if somebody is aggrieved by refusal of the distribution company, one of the examples, to grant an electricity connection, they may approach that body. So that order, your lordship will find at page number 260. This case has been registered on the basis of the complaint petition filed by Shri So-and-so regarding the settle of disputed demand in respect of Biscon Group of Industries. Lordship, I will just read the operative portion. It starts at page number 261. If I may, or should I read the entire thing, your lordship? Of 261, we have heard, this is the third paragraph, your lordship. We have heard both the parties and perused the record and relevant copies of documents filed by both parties in support of the respective claims. It appears that the complainant, Shri so-and-so, Messrs. So-and-so has applied for fresh service connection to the APDC. But it was informed that there is an outstanding due of amount rupees so-and-so only due from Viscon Group of Industries. The said amount is due to be paid as outstanding amount for getting a fresh service connection. From the bill bearing number so-and-so dated 27/10/2014, issued by APDCL, which shows that on 24/9/2014, PDC was made and an amount of rupees so-and-so only has been shown, and total payable amount has been shown as rupees 1,97,266. After making adjustment of load security of rupees 3,59,65,986 only, which includes interest. From the record, it appears that there are 5 consumers under BSPL Group of Industries, namely so-and-so, so-and-so, so-and-so. Brahmaputra Rolling Mills and Brahmaputra Tubular, after making temporary disconnection on 24/9/2014. Further, permanent disconnection of Brahmaputra TMT bars was made on 30/9/2014, after making TDC on 31/7/2013, that is after 14 months. This is where one of the disputes lie, Your Lordship. Why this permanent disconnection was allowed to extend beyond that period of 6 months up to 14. That is one of their claims, saying that beyond 6 months, since you are not permitted to do, they are not going to pay the load security. Furthermore, PDC of Brahmaputra so-and-so was made on 13/8/2016, after making temporary disconnection on 13/6. It is pertinent to mention here that in chapter 8 of AARC regulations, Lordship will kindly take a note of this. Chapter 8 of AARC regulations under clause 8.2 and 8.3. Even though this order is in my favor, in my humble understanding, the CGRF has made a mistake because he has applied chapter 8 of the regulations in force in 2017. But the disconnection and the permanent disconnection, Your Lordship, was done, Your Lordship, in 2014. So this, in my understanding, Your Lordship, this regulations could not have been applied. I will proceed now. Clause 8 in ARC regulations under clause 8.2 and 8.3 provides a detailed procedure for making temporary and permanent disconnection respectively. Clause 8.2.1 provides that where a person neglects to pay any charge for electricity or any sum due to him from a licensee by the due date mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 days clear notice in writing to such person and without prejudice to its rights to recover such charge or other sum by suit, cut off supply of electricity until such charge or sum together with any expenses incurred by him in cutting off and reconnecting the supply are paid, unquote. But this is not applicable in my understanding to the facts of this case. Further, clause 8.3b of the regulations provide that if the cause for which the supply was temporarily disconnected is not removed within the notice period, provided that if the service of the consumer remains continuously disconnected for 180 days, this is critical, Your Lordship, not being a temporary disconnection upon the request of the consumer, the agreement shall be deemed to be terminated on the expiry of 15 days or after expiry of the initial period of agreement, whichever is later, without prejudice to the rights of licensee or of the consumer under the Act for recovery of any amount due under the agreement. After termination of all agreements, the licensee shall intimate the consumer in format 20 of this code. Now, from the record, it appears that the aforesaid clause 8.3b has not been complied by APDCL while making permanent disconnection to Brahmaputra TMT so-and-so within the prescribed period of 180 days. However, out of 5 consumers only, the PDC of Brahmaputra so-and-so had to be deferred by the concerned officials of APDCL from time to time on their request to protect the interests of the consumers vis-a-vis APDCL, covering the time period from 1/7/2013, date of temporary disconnection, to 13/9/2014, that is date of PDC, permanent disconnection, which is, however, not allowable as per the AARC regulations. The Honorable Supreme Court in Civil Appeal number so-and-so in the case of Paschimachal Vidyut Vitran Nigam Limited, para 9 and 10 of the judgment held as follows. Can I read, Your Lordship? Very well. Yes, I'm reading from page 262 at the bottom of the. Yes. There has been a change in this legal position now after KC Nindan. Some change, not completely, but there has been some change. Yes.
As a supply and owner, parties to the contract.
Parties to the contract. a transferee of the premises
On a
cannot obviously be asked to pay the dues of his predecessor in title or possession, as the amount payable towards supply of electricity does not constitute a charge on the premises. There has been a change in the legal position.
on the premises.
There has been a charge, there is a charge, since it's a statutory charge, and if the property is sold on a as is where is basis, and if the supply code says that there is a charge on the premises, which the 2017 supply code does say, the new code now, under which he is applying, then your lordship, he has to pay. That is my understanding of the present legal position.
I don't think. It was not.
If your lordship has page number 264 then. I'll read from the bottom of 263, in fact, your lordship. That's where the paragraph starts. The complainant in his complaint petition stated that the 3% charge is applicable as in transformation loss if power is drawn below prescribed voltage, but the rule is applicable from 2017 and not before. Even this is a wrong factual position. As the line has been disconnected from 24/9/2014, which is not applicable to the complainant, on perusal of the documents available on record, it appears that in this instant case, the Biscon Group of Industries drew power on 33 kV instead of 132 kV feeder, which was the prescribed voltage as per the condition in sanctioned load and signing of agreement. It appears that there is a lapse on the part of the Biscon Group of Industries to secure the 132 kV feeder by paying the necessary dues to the AEGCL, which was erroneously said to be under the scope and ambit of APDCL. After going through the entire documents available on record and also going through the outstanding statement by memo number so-and-so submitted by the area manager, the amount of dues from Biscon Group of Industries and on the due date of PDC is rupees 8 crores 56 lakh 64,104 only, which includes the consumption charges of rupees 5 crores 98 lakhs 40,000 and rupees 2 crores 58 lakhs 22,690 as LTML charges. And the complainant to pay the entire area amount for getting fresh connection for supply of electricity, the new identity to the APDCL by observing the rules and procedures formulated by APDCL.
Okay, then what happened?
They challenge this order before the electricity ombudsman. This is the appellate forum created by the relevant rules. Your lordship will find the order of the ombudsman, which is the order I have challenged in my writ petition, at page number 271. This is a judgment of 15/11/2022. So lordship will find the point.
Yet have an electricity connection.
No, they now have an interim order where temporary connection was directed to be provided. Payment of charges. The lordship will see the points of determination. The facts I have already placed before lordship at page number 288. 5 points of determination were framed by the learned ombudsman. Whether electricity dues to the previous owner can now be brought upon the auction purchaser, that is the new owner of the plot of the land. Whether the judgment dated 22/12/2021 passed by the learned CGRF is liable to be interfered with. Whether the charge for LTMU loss is recoverable from the appellant for the period from July 2006 till July 2013. Whether the fixed charge can be levied for the period beyond what is prescribed, that is 195 days. That is 180 plus 15 days of temporary disconnection. 195 days. Whether a new consumer can be deprived of electrical connection if approached, if no dues are there. The lordship will find the findings of the conclusions drawn by the learned ombudsman. They start at page number 288 itself. So I'll just read. Even the first one is important because it completely goes against the judgment in case in Nindan. I mean, yes, they say that it does not. Even the first point of determination, that is also critical. Whether the electricity dues to the previous owner can now be brought upon the auction purchaser, that is the new owner of the plot of land. It is a settled law that dues that arises in a plot of land which is recoverable. Lordship, why I am troubling your lordship with this? Because the law that has now been laid down by the Honorable Apex Court, they have a direct bearing to these legal formulations that have been laid down by the ombudsman. So I'll just read through your lordship. It is a settled law that dues that arise in a plot of land which is recoverable through due procedure of law is recoverable from the new owner. If we examine this minutely, it transpires whether this is this recoverable dues from the property stroke loan were sought to be recovered during the period when the erstwhile owner was in possession stroke ownership of the property. Creditors have various channels to move for recovery of dues like DRT, area of land revenue, moving a civil suit, etc. Surprisingly, it is seen that due diligence regarding the timely payment of electricity dues, as well as arrears, was not maintained by the DISCOM, which in this case is APDCL, who are the respondents of this appeal. Another important point in this regard is that if there are any dues by the BISCON, it cannot necessarily be passed on to the subsequent owner if the land stroke property is bought on the auction. In this regard, there is a clear judgment by the Honorable Supreme Court of India in civil appeal number so and so, Isha Marbles versus Bihar State Electricity Board and another, where it was ruled where premises owned by auction purchaser, when such purchaser seeks supply of electrical energy, he cannot be called upon to clear past dues as a condition precedent to supply. What matter is contract entered into by erstwhile owner with board. Board cannot seek enforcement of contractual liability against auction purchaser who is a third party. The Honorable Supreme Court goes on to state that, but the law as it stands is inadequate to enforce the liability of the previous contracting party against the auction purchaser, who is a third party as in no way connected with the previous owner stroke occupier. It may not be correct to state, and if we hold as we have done above, it would permit dishonest consumers transforming in their units from one hand to another from time infinitum without the payment of dues to the extent of lakhs and lakhs of rupees, and each one of them can easily say that he is not liable for the liability of the predecessor in interest. No doubt dishonest consumers cannot be allowed to play truant with the public property, but inadequacy of the law can hardly be a substitute for overzealousness. Clubbing up new electricity connection with old dues will not be justified on the part of the respondent, and the respondents may move for appropriate action in recovery of dues, if any, through proper procedure. So whether the judgment dated so and so, he has said that judgment is wrong. 2. Point number 3, whether the charge of LTMU loss, this is important, Your Lordship, is recoverable from the appellant for the period of July 2005 to July 2013. In this point, we need to understand two things: whether LTMU charges were at all an arrangement of the contract between the previous owner, that is Brahmaputra TMT Bars Private Limited, and B, whether LTMU charges or any electricity charges can be recoverable after due date, which in this case, and C, whether in the Honorable Supreme Court Civil Appeal number so and so, Ajmer Vidyut Vitran Nigam Limited versus Rahmatullah Khan, and Civil Appeal number 7235/2009, Mrs. Prem Cortex, respondents will be applicable for justifying the exception to the limitation which is given under section 56(1) and 2 of the Electricity Act of 2003. It is seen that a number of bills were raised with the Brahmaputra TMT Bars Private Limited, as for example 45648 dated 15/7/2013, bill number so and so, where it is mentioned that Brahmaputra TMT bars are categorized as HT industries, and in those bills, no LTMU charges were there. It is clear from the bills that the LTMU charges were not at all under the purview of the DISCOM. Your Lordship will kindly take a note of that. At page number 290.
No.
He's saying that it is not within the purview. So that is his perception. His view is that it is completely not within the purview of the DISCOM. Now comes the question. Now comes the question as to why a bill of rupees 4,03,95,584 was brought against the erstwhile consumers Messrs. So and so through an assessment bill number so and so. In this regard, the respondent was transparent to file during the course of hearing the Comptroller and Auditor General of India report on public sector undertakings for the year ended 31st March 2016. Now, if we examine the relevant portion, which is 3.2 of the CNAG report, it blames the APDCL for not having certain provisions in place, leading to transmission loss and thereby revenue. I have already taken your Lordship through the entire thing. 292, your Lordship. Your Lordship has page number 292. This is a finding of the Ombudsman, which I believe is completely wrong. The respondent DISCOM took a laudable step by plugging the loophole in codifying the Electricity Tariff 2017, wherein it was stated for supply at voltages higher than is applicable to the consumers, rebate at the rate of 3% shall be applicable on energy consumption for each higher level of voltage, and a surcharge of 3% shall be applicable if consumer draws power at lower than the applicable voltage level. Apparently, after receipt of the CNAG report, the LTMU charges were sought to be levied in 2018, even though this provision of 3% surcharge came into existence in 2017, much after permanent disconnection in 2014. It cannot be permitted that a due can be made recoverable when no tariff to that effect existed prior to 2017. In the judgment of the Honorable Supreme Court in the case of so-and-so, it was ruled that there can be no retrospective effect of a statute or statutory rule. The codification of 2017.
You say that this is wrong.
I say that this is wrong, that there was a tariff code in that relevant period under which we could have levied a penalty surcharge for drawing connection electricity at a higher voltage. That is a part of the record.
There was already some.
There was a tariff. There was a tariff order.
Was it placed before the ombudsman?
I believe it was not, because there was no mention of this in the order. Yes, it is. It is before the. It is before. It is a part of the record in these proceedings.
It was 3% at that point of time.
Yes, your lordship will have the tariff
At
order.
that point of time, was it 3%?
It is there. My understanding of what my instructions are, if your lordship has the tariff order, page number 210.
210?
Yes, your lordship.
Yes.
Then the 6 are over.
Is it?
Your lordship has the first column, the part in bold at the top of the page, which says HT group at page number 210. This is the tariff order. Tariff for this group is applicable for those consumers availing power supply at 11 kVA or above. Calculation shall be deemed to be in kVA for consumers under this part of the tariff schedule. However, consumers above 25 kVA connected load and drawing power at LT are also covered in this under this group. During this period of conversion from LT supply to HT supply, the consumer shall have to pay the necessary compensatory charges, which is amounts to 10% and 3% of total energy consumption for LT line and DTR respectively. So my instructions are that under this provision, we are authorized to levy that charge of 3%. Has been done after the CAG report. Yes, who are LT.
And drawing power at.
Yes, at low tension. So during that period from
under this group.
Yes, during that period of conversion from low tension to high tension, they have to pay compensatory charges, which amounts to 10% and 3% of total energy consumption for LTA line and DTR respectively. I have been instructed that under this clause, we are empowered to levy that compensatory LTMU charges of 3%, which is admittedly done after the CAG report. That is the second limb of the dispute. Because if you're otherwise, the word surcharge, your lordship, in the earlier provisions, there was only a question of rebate to the consumers. For example, if we are not able to provide to them, then they get a rebate. But now the word surcharge was brought in for the first time in the 2017 supply code. But as per the tariff order, which was applicable, and then the tariff order of the financial year 2006-07, applicable to that case in hand, we are empowered to levy compensatory charges of 3%. It was never converted because at that point there was, we should have done it. The CAG report rightly says that we should have done it.
How we fall in it, that clear. So let him explain how we fall in it.
What I was trying to find out.
This clause, how we fall in it, let him explain. May I have the instructions?
5 kVA.
Yes.
He was a consumer above 25 kVA.
Yes.
And drawing power from an LT.
Yes, your lordship. And since he had to convert his transformer to a 132 kV transformer, and that payment was not done, not him, the other previous owner, that was not done. That is why APDCL is empowered to levy the LTMU charges. That is my instruction. That
Lordship, well, if you lordship permit me, I'm not disturbing, my lord. But this is the crux. He is again and again saying that he has got the instruction.
That is what I was
My
afraid
lord,
of asking
instructions
him.
means, my lord, he is not satisfied.
The
but he has the
difference between
instructions.
instruction and understanding. Yes,
Yeah.
we will not ask you that.
He is not satisfied, but he has the instructions. Your lordship may kindly read, my lord, once again for the if I without disturbing, with his permission, my lord. Tariff for this group is applicable for those consumers availing power supply of 11 kVA and above. Calculation shall be deemed to be kVA or consumers under this part of the tariff subscription. Now, however, from here it is important, my lord. However, consumers above 25 kVA connected load and drawing power under LT.
low tension.
Below your lordship, may kindly note it, my lord. Those above 25A and drawing power under low tension are also covered on this group. During this period of conversion from LT supply to high tension supply, so there must be a transfer from LT to high T.
Yes. To
In our case, we were high tension from the very beginning, and there was no conversion from low tension to high tension.
what I was trying to find out
So, my lord,
was that they were in the LT at any point of time, sir.
No, what this clause, your lordship, if your lordship has the tariff order, it says that those who are high tension consumers, but drawing power at low tension. If your lordship has the letter, which was the first letter which was sent to them, which is at page number 207, letter which I had shown your lordship.
Are you drawing it?
Yes, my understanding of this is what I have been instructed, that the transformer which they were drawing electricity from, till it was converted to 132 kV, that would amount to LT. And since that conversion was not done, they are liable to pay LT. That your lordship will find at 207.
Can you note?
That from the in the record, that is not there. Apart from this communication at 207, your lordship.
So page
7.
20.
207. With reference to the above, I'd like to inform you that as per regulation 2.2 of the terms and conditions of year 2007 notified by the ARC, the normal supply voltage for connected load above 5000 kVA is 132 kV. As your present connected load of 11076 kW far exceeds the above requirement, you are therefore requested to make arrangement for conversion of your supply voltage from 33 kV to 132 kV.
higher.
Yes, they have to make arrangement to convert it to HT. They were drawing it at 33 kV at yes.
Three cable. Just convince high tension, not from low voltage to high voltage. Am I being
Yes,
able
Your
to?
Lordship.
Once you say that 25 kW high tension, you are giving me your impression that even 25 kWA can be on low tension and it can also be on high tension.
Yes.
But if it is on low tension, it requires to be
Converted to
high tension.
high tension. 132 kV.
I do not find anything in this report till now
Yes.
to understand that whatever of the W load, whatever it was existing on a now to a high tension. On a high tension. On that high tension.
Then it will not, then this provision
Clause will not apply.
may
Now,
not be, may not
we
be
do
applied.
not find anything till now to convince ourselves that yes, there was a conversion. It is not that you don't have a case, it is that this letter will not help you. This tariff of 2006-7 which you are trying to argue, not help you. There is no conversion. The voltage conversion we understand. You are being supplied 25 kV. You need to take a permission for 132 kV. You need a supply for 132 kV. Please arrange. That is one aspect. Low tension from what we have understood till today, what wires we see connection. These are LTs. Between the big agricultural fields that high ones, those are the HT connections. Some running through Guwahati, of course, we know of them. That is a high tension wire, which are now required to be removed from all. That is different aspect.
Your lordship has the supply code applicable then. There the definition is there of what amounts to low tension. This high tension.
Bill, that may help. It says LTH, somewhere it says. Even in our electricity bill, it says.
No.
38. Category.
No, category, if they are at lordship, we kindly have this. The relevant portion of the
Low tension, single phase, 230 volt.
low tension is single phase 230 volts and three phase 400 volts.
Well, three phase, so 11 kV or Iman between the phases. Very well. He was already at 25.
Yes.
So he has to be at the high tension.
He has to be at the high tension.
Therefore, the bill app page 138 is high tension.
No.
Where is the conversion part?
Because what the APDCL is, my instructions are, your lordship, is that even if he's because of his consumption, your lordship, he has to be supplied electricity, lordship, from a transformer which is of 132 kV. If that transformer is not installed, then there is a transformation loss which cost to the distribution. Now, because of that, they are saying
you overlooked.
That was overlooked.
You overlooked.
That was overlooked.
CAG got into action.
CAG got into action.
Some advices. You made corrections.
We made the correction. Retrospectivity issue, I can satisfy lordship, whether the correction is right or not. But the first issue
Whether
is,
it can be applied like that.
no,
We correct it for 3%.
as far as the retrospectivity issue, the judgment of the honorable, once if a bill is not drawn, negligence or mistake, your lordship, till it is not levied on the consumer, the provisions of section 56 of the Electricity Act.
Levied nothing till 2014. You
Yes.
want to say.
So
Although there are documents saying that you are levying the bill.
we should no.
You have levied the bill.
We have not levied the LTMU charge.
Can you do that? Is the issue?
Yes, as far as retrospectivity is concerned, your lordship, perhaps my understanding is that can be done. But whether it was correctly applied or not, whether we could have applied the LTMU charge or not.
The conversion from HT.
On this issue, your lordship, if you
33 kV, high tension, your definition.
Yes. Yes.
kV or 33 kV.
Lordship, as per that definition, it is definitely, as far as the voltage is concerned, that is definitely is up to, I believe, LT is up to
kV.
From 11 kV to 33 kV, it's definitely high tension.
Only volts. It is
Volts.
not even.
For low tension, it is volt.
30 volt.
Yes.
Phase is 400 volt.
Yes. And high tension is 11 kV and kV.
Kilovolt.
Kilovolt.
Thousands.
Kilovolt.
Hundreds, that is in thousands. Earlier owner of that KVs.
He was definitely. If other than this,
Again, the
tariff
drawing
model-
part, where is the drawing?
But your lordship,
That
the letter is at page number 207, your lordship.
no.
7.
What was applicable in
The tariff order, your lordship will find at 209. .
at LT. Your bill in 2013 clearly shows HD.
Yes, Your Lordship.
They're the only documents.
These are the only document. This is the document I'm relying on as far as the LTMU issue is concerned.
You're saying HD. But on anything to show that there was some
Apart from this, there is nothing.
at LT.
Yes. So on this issue, Your Lordship, on the LTMU issue, if Your Lordship permits me, or if Your Lordship so directs, and engineer, Your Lordship, in fact, who had represented APDCL for both the authorities, if I can ask present in person, so that not any issues, technical issues, Your Lordship.
Possible once again, see the CAG report also. Just take the trouble, my lord.
We are just trying to cover up each issue.
Yes.
Athak.
Yes,
We are
yes.
trying to understand
Very
at a
good.
go.
228.
Page 230, my lord, the relevant part. I was just trying to solve whether the provision was there or not. The audit itself says that the provision was not there. Last but one paragraph, my lord. In the absence of any stipulation in this regard in the ARC regulation, audit considers the rate of 3%. So the audit is saying that there is a absence of provision. Such a provision is not there. And after this,
I'll-
my lord, the amendment was made. And
I'll
now it has been imposed in 2017.
I'll just explain this, what this
Fine,
line
fine.
refers to. Audit considered the rebate of 3%. This is a 3%, if Your Lordship has the tariff order again, that is quoted in the tariff order also. In the earlier tariff orders, if Your Lordship has page number 210, for supply, if Your Lordship has page number 2210, at the bottom of the page, the second bulletin. For supply at voltages higher than as applicable to consumers, as per section 2.2 of the ARC supply code. This is a supply code which I just handed over. And related matters regulations 2004, rebate at the rate of 3% shall be applicable on energy consumption for each higher level of voltage. The industrial connection. No, I understand, Your Lordship. This is what the CAG is referring to. I am not relying on this.
We were relying on
saying-
it a few minutes ago.
I am saying, Your Lordship, the CAG is relying on this 3% rebate to calculate that 3%, why it should be 3% surcharge. I'm just referring to this to explain how the CAG got that 3%, Your Lordship. That 3% which they have figured.
Voltages.
We cannot definitely rely on this. He cannot rely on this. I am just showing it to Your Lordship to show how the CAG arrived at that.
Rate at the rate 3%. Higher level of voltage.
That is since there was a rebate to be done, rebate to be provided to the consumer. If energy was provided at a higher level, the CAG is saying that if it is being provided at a lower level due to a fault of the consumer, then a surcharge should be applicable. That is how they have arrived at the 3% figure.
Cannot do it. Rebate. Consumer does not do it.
Then surcharge.
Surcharge.
That is, I'm only showing this to show how the CAG arrived at the 3% figure, not for. So regarding the retrospectivity issue, then perhaps I may not to then advance arguments, though I believe I can satisfy Your Lordships.
17 also.
2017 amendment, I am not going to show Your Lordship why, because this amendment was not in force at that point. This was a dispute which has arisen in 2014. So showing the 2017 amendment, where now they are definitely
Show
certain.
me something that you can levy the.
Now we can.
Now you know upon the person concerned.
At that point, the 2017 was I am very clear about this, that cannot be retrospectively applied.
Then,
2017 amendment.
Then
as far as the LTMU loss is concerned, apart from this tariff order, Your Lordship, we have no other authority to allow us to levy that LTMU.
and you also do not have anything on record to during that period.
There was apart from this
Because
letter,
the conversion process will perhaps start perhaps start once you make a demand that you convert it to LT.
Correct. What has
Or
happened,
he makes an application that convert it from LT.
what appears to have happened in this matter, Your Lordship, this is not a part of my brief, but what has happened is the requirement of conversion in this matter is from HT to EHT. It was so high, if Your Lordship has that voltage chart, it is actually from HT to EHT. I may be wrong, I'm not a technical person.
This is applicable.
This is, that is why I had made a submission saying that my instructions are that this is.
LTMU,
Yes. Then the second part, Your Lordship, is the position of the load security. So we were in the order of the ombudsman. Fixed charges, fixed charges, fixed charge, fixed
You
charge.
have already disconnected it in.
Yes. So the fixed charge is up to that point of disconnection. They are saying that we could not have levied the fixed charge beyond that period of 195 days. That is 15 days of temporary disconnection and 180 days, 6 months of PDC.
AU finally disconnected it.
We have levied it up to that date.
And they want to say that from 2006.
They want to say that
from the date of temporary disconnection.
from 31/7/2013, 6 months.
That 6 months beyond that you could not have gone.
That is the crux of the dispute regarding fixed.
You allowed them to draw connection, to the connection to remain there
Yes,
because they made some prayers.
at the request of the former owner.
But it was your decision to do it.
Now, there are two themes of argument, Your Lordship. One is when the owner has himself consented to this, they have stepped into his shoes, and former owner never raised any objections. Can they now come and object to that levy of the charge, which was because there was no privity of contract between us and them at that point. Is there any privity of contract now? But at that point, there was no privity of contract. The party with which we had an agreement, they consented that, okay, fine, give us some time, but don't discount. They never raised any objections. So once having stepped into their shoes, having brought the property on an as is, can they now object?
Step into their shoes or as their liabilities to the electricity bill is.
Yes, they have. From the supply code and the Supreme Court judgment of KC Nina. If I may now take Your Lordship to the findings of the Ombudsman on this issue. Your Lordship will find this issue at page number 293. Whether the fixed charge can be levied for the period beyond what is prescribed. From the nature of the argument, it is seen that there existed an office order dated 30/11/1992, issued by the then additional chief engineer in commercial. Excerpt of the said office order is reproduced as for the disconnected consumers. The minimum charge is to be levied for a period of 6 months only. As per clause 8, B and C of the terms and conditions of supply 1988, if the service line remains disconnected for a period, Lordship, can you take a note of this? Terms and conditions of supply 1988. I do not know why they are referring to this. Because at that point, when the dispute arose, the 2007 amendment was in force. Why they referred to the 1992 office order and the 1998 supply order, I find it difficult to fathom. If the service line remains disconnected for a continuous period of 6 months, the board may dismantle the service line material, etc. after serving a moment's notice to the consumer. It seems that on the insistence of the erstwhile consumer, the temporary disconnection was delayed till September 2014, whereas it should have been disconnected in January 2014. The delay was purely an internal matter of understanding between the respondent DISCOM and the erstwhile consumer on humanitarian grounds. The continuance of temporary disconnection up to September 2014 is not backed by any rule in force. Now, asking the present owner, that is the petitioner, to pay the fixed charges from February 2014 to September 2014 is not sustainable. And the demand made by the respondent on the petitioner for the period from February 2014 to September 2014 is liable to be set aside. Executive head is to inquire into the matter why such allowances to the previous consumer was allowed by the responsible functionaries of the DISCOM and a report submitted. Also, the bill submitted so and so is set aside. Now, my understanding, Your Lordship, is that this dispute, Your Lordship, the supply code of 1998 and the order of 2000 and 1998 and the order of 1992 of the erstwhile ASEB, perhaps they should not have been applied. There was a supply code which
What was supposed,
there's a supply code which I placed before your lordship. That should have been applied.
what is the time period given?
Yes. Here, if your lordship has
What is the time period?
temporary disconnection, lordship will have page number 1214. Where a person neglects to pay any charge, this is disconnection of service, disconnection due to non-payment. Where a person neglects to pay any charge for electricity or any other sum due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 days clear notice in writing to such person and without prejudice to his rights to cover such charge or other sum by suit, cut off supply of electricity until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting a supplier paid but no longer. The licensee shall be entitled to terminate the power supply in case the person shall not be entitled to terminate the power supply in case the person deposits under protest the electricity charges payable from him for each month calculated on the average of 6 months. 4.3.2, here it's the other way around. Here says that if he deposits it, then we cannot disconnect. But it does not lay a mandate, your lordship, saying that if he does not deposit it within 6 months, then we have to disconnect. I'm arguing the other way around. Your lordship has the language. Licensee shall not be entitled to terminate. The electricity shall not be entitled to terminate the power supply in case the person deposits under protest the electricity charges due from him for each month calculated based on the average of the past 6 months. So I am saying that as far as this supply code was concerned, your lordship, there is no distinction between a temporary disconnection and a permanent disconnection. Upon non-payment, by giving 15 days notice, we can disconnect, but there is no limit of 6 months which has been laid down. Now, even for the sake of argument, if your lordship holds that there is a limit. Now, once the original consumer says that give us a relaxation, that relaxation has been granted to him. 1988 and 1992 is wrong. 2007. Might have been different. And my second lever argument is that considering, let's for the sake of argument assume that there is a limit of 6 months there. Let's assume that the order of 1992 still holds the field. When then, once the original consumer has consented to it, because if the original consumer, lordship will just see, if the original consumer was here, he could not have objected that they are levying fixed charge beyond the date of beyond the date of 6 months, because he has himself consented. On his request, it was done. And when it was done, he was the consumer, not the respondents. So once the respondents have stepped into their, can they be allowed to take that benefit, your lordship? So now if
But this 4.3.
4.3.3 is recovery of old dues, notwithstanding anything contained in any other law for the time being in force. This is regarding that no sum due from any consumer under this section shall be recoverable after a period of 2 years from the date when such sum became first due, unless such sum has been shown continuously as recoverable as areas of charges for electricity supplied. Regarding that retrospectively of the LTMU charge, which I have said that has been read down by the Honorable Apex Court. In fact, this very supply code was under consideration. This actually means This means that if there was a bill which was raised for X amount, and then for that you have not taken any steps for recovery of that amount for 2 years. Then after the 2-year period is over, you cannot use your powers under 56 and say that if you do not pay up, I'm going to disconnect. It only 50. What this means is that power of disconnection under section 56 is taken away from you after 2 years. But suppose an amount is not shown as recoverable, negligence, bona fide mistake, then you can levy it at any point. But even in such cases, you cannot use that power of disconnection to recover that amount. Some other means of recovery.
To give a new connection.
That can be resorted to because that the Supreme Court has said. Other powers as stated in the supply code also.
Yeah,
The new supply code of 2017 says that old dues have to be cleared.
2017.
Now he is applied under 2017 code. Old dues have to be cleared. If I may take your lordship to the Supreme Court judgment first. This judgment, your lordship, primarily there were petitions from across the country, and the core issue, your lordship, was the applicability of section 56 and whether an auction purchaser or the purchaser of a property can be foisted with the use of the former owner. Both these issues were decided. So I'll not trouble your lordship with the entire thing. If your lordship has paragraph number 23, I'll just place it so that it's on 23. The issues are there. I'm particularly relying on number C, your lordship, whether the power to recover arrears of a previous owner or occupier from an auction purchaser of the premise falls within the regulatory regime of the 2003 Act, whether the power to enable the recovery of arrears of the previous owner or occupier from auction purchaser can be provided through subordinate legislations by the state commissions. Then issue number F, whether the statutory bar on recovery of electricity dues after the limitation period of 2 years provided under section 56 of the 2003 Act will have an implication on the civil remedies of electricity utilities to cover such areas. And G, what is the implication of an auction sale of premises on as is where is basis with or without reference to electricity areas of the premises. Now, the conclusions, your lordship, if I may take your lordship directly to the conclusions, because that will save us some time. Your lordship will find that page, paragraph number 327. Taking all facts and circumstances into consideration, including the lapse of more than 2 decades in the appeals were filed before this court. And paragraph number 327, your lordship. In response. Just bear with me. 341 from that copy. I was 341 from that copy. Taking all facts and circumstances into consideration, including the lapse of more than 2 decades since the appeals were filed before this court, and the equities arising in favor of one party or the other, we direct the electric utilities to waive the outstanding interest accrued on the principal dues from the date of application for supply of electricity by the auction purchaser. Conclusions. The conclusions are summarized below. The duty to supply electricity under section 43 of the 2003 Act is not absolute and is subject to such charges and compliances stipulated by the electric utilities as a part of the application for supply of electricity. The duty to supply electricity under section 43 is with respect to the owner or occupier of the premises. The 2003 Act contemplates a synergy between the consumer and the premises. Under section 43, when electricity is supplied, the owner or occupier becomes a consumer only with respect to those particular premises for which electricity is sought and provided by the electric utilities. For an application to be considered a reconnection, the applicant has to seek supply of electricity with respect to the same premises for which electricity was already provided. Even if the consumer is the same but the premises are different, it will be considered as a fresh connection and not a reconnection. A condition of supply enacted under section 49 of the 1948 Act requiring the new owner of the premises to clear the electricity arrears of the previous owner as a precondition to avail electricity supply will have a statutory character. The scope of the regulatory powers of the State Commission under section 50 of the 2003 Act is wide enough to stipulate conditions of recovery of electricity arrears of previous owners from new or subsequent owners. The Electricity Supply Code providing for recoupment of electricity dues of a previous owner from a new owner have a reasonable nexus with the objects of the 2003 Act. The rulemaking power contained under section 181, read with section 50 of the 2003 Act, is wide enough to enable the Regulatory Commission to provide for a statutory charge in the absence of a provision in the plenary statute providing for a creation of such charge. The power to initiate proceedings by filing a suit against a defaulting consumer is independent of the power to disconnect electrical supply as a means of recovery under section 56. The implication of the expression as is, where is basis is that every intending bidder is put on notice that the seller does not undertake responsibility in respect of the property offered for sale with regard to any liability for the payment of dues like service charges, electricity dues for power connection, and taxes of the local authorities. And in exercise of so and so, that part is a specific direction which has been passed. So from this judgment, what has been culled out, Your Lordship? The 2017 Supply Code, which is present, applicable to the present, to his electricity connection, it provides for recovery of previous charges, then he is bound to pay them. Now, I'll establish it for Your Lordship. What I am trying to place is the 2007 code does provide for the same, and the 1998 Supply Code and Order 92, Order of the Engineer AACB, is not applicable to this issue of connection of the calculation of the fixed charge.
Issue is yes, yes, ma'am.
Thank you.
Their understanding is that before the CAG, when the CAG report came, that you should have with the 3% LTMU, their understanding is that if a customer wants at X, but we are giving him at X minus 1, then we have to give him a rebate of 3%. So if the customer wants at X plus 1, but he's only taking at X, so then we should get a surcharge of 3. So apart from that, apart from the tariff order, there is in fact nothing else which supports. That may not fall from me, Your Lordship, but that supports the levy of the LTMU. That is regarding the LTMU issue. Regarding the fixed charge issue, Your Lordship, I was referring to KC Ninnan. There that copy. So the law which has been laid down by the apex court is a subsequent purchaser buys a property on an as is where is basis, takes over the electricity charges, and if the relevant supply code provides that payment of such charges is incumbent for him to get a fresh connection, then he is duty bound to pay those. That is the law. So when the present respondent, Your Lordship, applied for the electricity connection, the 2017 supply code was still in force.
No, that he is required
All
by his predecessor.
the fixed charge and the outstanding dues of energy consumption he has to pay, Your Lordship. So it's not my Lordship, they are saying that it's not disputed.
Lordship has been.
Yes, I'll satisfy Your Lordship on that. I'll satisfy Your Lordship on that.
Otherwise, you don't have to.
So if if Your Lordship has the 2007 supply code, the one which I had given before, that was the supply code which was holding the field when the disconnection and took place. As per that supply code, if Your Lordship has that relevant provision of that supply code, which is clause 4.3.1, Lordship will kindly see the word may has been used at page 1214. That the word may perhaps come to my aid here, Your Lordship. Disconnection due to non-payment. When a person neglects to pay any charge for electricity or any other sum due to him from a licensee by the due date mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee may take a note of the word may, after giving not less than 15 days clear notice in writing to such person, and without prejudice to his rights to recover such charge or any other sum by suit, cut off supply of electricity until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting the supplier paid but no longer. So this is a directly, not a mandatory provision. A power has been conferred on the distribution licensee, where he may exercise that power of disconnection under section 56 to recover his dues by giving 15 days. But the period of 6 months which has sought to be added to this provision, Your Lordship, that in my humble submission is not there. That may have been there in the 1988 supply code which the ombudsman referred to, or in the order of 1992. But since the terms and conditions of supply with the predecessor of the respondent were governed by this supply code, Your Lordship, in my humble understanding, the limit of 6 months cannot be added, because the discretion has been granted. And here the discretion was exercised because his predecessor asked us to. His predecessor said that kindly defer that period. So he deferred it in his interest. From the order, Your Lordship, it does not appear to. They were there, memorandums were filed, Your Lordship, but those are not available with me. And from the order, it appears that this supply code was not considered by him. There is no discussion on this provision of the supply code in the order of the ombudsman.
1988.
1988 and the 1992 order.
The order reflects.
That's what the order reflects. So now, so apart from, so my understanding is that the fixed charge, which the predecessor of the respondent could not have objected to, that cannot be objected to by the, since he has stepped into his shoes and he has brought the property on an as is where is basis, as was evident from the certificate of sale that placed before Your Lordship. So if I may take Your Lordship to the new supply code, which is present 2017. Lordship may have clause 5.8.3.1. This is at page number 56, Your Lordship. Where I am referring to clause C or subclause C, page 56. Where an applicant has purchased an existing property whose electricity connection has been disconnected, it shall be the applicant's duty to verify that the previous owner has paid all dues to the licensee and obtained a no due certificate from him. In case such no due certificate has not been obtained by the previous owner before change in ownership of property, the new owner may approach the licensee for such a certificate. The licensee shall acknowledge receipt of such request and shall either intimate in writing the dues outstanding on the premises, if any, or issue a no due certificate within 1 month from the date of receipt of such application. Then Your Lordship may have clause 5.8.3.2 C at page 57. Any charge for electricity or any sum other than charge for electricity as due and payable to licensee, which remains unpaid by a deceased consumer or the erstwhile owner stroke occupier of any land stroke premises as the case may be, shall be a charge on the premises transferred to the legal representative stroke successors in law or transferred to the new owners of the premise as the case may be, and the same shall be recoverable by the licensee as due from such legal representative or successors in law or new owners stroke occupier of the premises as the case. Yes, Your Lordship. Yes, sir. Your Lordship has the format of the agreement which is to be signed. In fact, for both low tension and high tension consumers, the form, Your Lordship, it begins at page 134. I am referring to page 135, clause 3. One of the clauses is that the consumer shall pay the outstanding electricity bill, if any, due from the previous owner, if the premises has been purchased by the consumer prior to release of the fresh service connection. The same clause is there for high tension consumers also at page 158. 158. First one I was reading from 135, Your Lordship. That is a part of the agreement to be executed with low tension consumers. Clause 3. Page 135.
Back here. Totally.
I'll give my copy here. Lordship will have my copy. Lordship will have my copy. It's 130.
Even for supply of electricity.
Yes. Yes, your lordship, clause 3.
with director.
No, clause 3 of the, that's 2017 code, your lordship. Clause 3 of page 134 of that document. 34, it starts at 134.
David.
Lordship will have this. Here it's 132. Clause format. For low tension consumer, it starts at page 131. And the relevant clause, your lordship will find at page 132, clause 3. Consumer shall pay the outstanding electricity bill, if any, due from the previous owner if the premises had been purchased by the consumer prior to release of the fresh service connection. Similarly, for high tension consumers, this format 4.4, which your lordship will find at page number 158, your lordship. This is for high tension consumers. The consumer shall pay the outstanding electricity bill, if any, due from the previous owner if the premises had been purchased by the consumer prior to release of fresh service. So for both low tension and high tension consumers, there is a requirement as per the supply code that the dues of the previous owner has to be paid, and the charge now has been made a charge on the property rather than a charge on the person. So my submission is that since the original owner did not object to the fixed charges, it was at his request that period of 6 months was extended, and that is not specifically barred by the applicable supply code. So it may not be permissible, but there is no bar. So unless there is a bar and there is both the parties, it's a commercial transaction which they acceded to. There was a meeting of minds between both the electricity and the consumer. The person who has stepped into the original consumer's shoes now, he may not be perhaps allowed to raise that objection now at this stage. So that is my submission. I reserve my right to a reply if there is something.
And another friend was taking much trouble that I am estimate dues are outstanding are for the earlier owner. I've never said that I will not liable to pay. In fact, I submitted letter also. Your ultimacy page 69 of the first writ petition below.
We have that only. That only.
I wrote. The 22. Also, you see the fourth paragraph from the bottom. Said, my lord, that our line has been permanently and the arrear amount is so and so. We are ready to pay the amount of rupees so and so, which includes so and so. Whatever, my lord, said, my lord, that whatever amount is legitimately due, we are ready to pay. The judgments and all other issues that I am liable to pay an agreement, all those issues are no longer there because we are not disputing whatever amount was due effect of the erstwhile owner. But it must be legitimate due. It cannot be said, my lord, that whatever demand was there, that has to be paid, that it cannot be said. While another friend was again and again saying that the earlier one consented, so you have to pay. Whatever he has consented, you have to pay. The lordship is aware. Consent was for what? It was respect of the only fixed charges because in 2018 only the bill or LT was raised. So charges, well, fixed charges, whatever are there, if it is payable for 6 months, the APDCL cannot charge more than 6 months on the consent of the parties. Well, this duty, charge, tax, etc. cannot be levied on the basis of the consent of the parties. Assuming, my lord, I'm just giving example. A rate is prescribed for 4%. I give a consent as 6%. Whether they can levy for 6%. So consent cannot empower the authorities to levy more than whatever is prescribed under the statute. If it is more than 6 months, your lawsuit will hold it 6 months. He's liable to pay for more than 6. If it is 6 months, then my lord,
So as it is 6 months.
I fully agree with you, lord. It's not there. 92, it is there. 2017, it is there. But in 2007, it's not there. I will not dispute that aspect of the matter. That only thing that I am disputing is that, my lord. While another friend is saying that may up to disconnection. Now the 15 days notice was given. Once the 15 days notice is given, you know, once again see, my lord. Close.
But all the while you proceeded on the
My lord.
No, because
all the time, because July you give that notice, bring a bill till January and say specifically that your 6 months is over.
perhaps a mistake of the legal position by.
My lord, the mistake.
Yes, but
Correct it
that will
now.
not, that will not give rise to, a mistake of law will not give rise to any right, your lordship. This is the statute which holds the field 2007. No requirement or limit of 6 months prescribed. My understanding is that officer making a mistake of law perhaps will not bind the.
What are you making a mistake?
A mistake of law.
Concern. Individual concerned. And at that point of time, you took it to be 6 months.
Extended.
The understanding that it will
That
do it in
officer.
6 months.
Yes.
Then the officer gives the concession and therefore the ombudsman again says, find out that man who did it illegally.
But thankfully, maybe
Okay, just
thankfully
fine.
for him that there may be a way out in this code.
The licensee may, after giving 15 days notice. Now, he may not give a 15 days notice. Right? That please don't discuss. You have given a notice for 15 days. You have given a notice for 15 days for disconnection. Once you issue a notice for disconnection for 15 days, whether thereafter, if you don't disconnect on one ground or other, whether the time limit of charging of fixed charges will exceed. I give a simple example, my lord. A provision says that, my lord, time limit is 5 years, 4 years, etc. is there. A notice is issued prior to that period. As per the Act, 15 days notice is given, notice is issued. Thereafter, no action is taken. No action is taken on the ground, my lord, that the person concerned has made a request not to disconnect. Whether that will empower the authorities to continue to have the fixed charges, assuming, my lord, for 2 years they don't disconnect.
Accepting your argument, perhaps it will become a go in perpetuity. You may not do a disconnection notice. Liability, you must
Because
find the
this-
liability all the while.
This provision, your lordship, my understanding is
It becomes indefinite.
once the word may is there, after that there is a comma, then requirement is of giving a notice. The requirement of giving a notice is mandatory. Discretion is given regarding the intention to disconnect. So if you disconnect, then you definitely have to give the notice.
But the may, as you lordship is aware, may always doesn't mean that it is a discretionary. And shall also, my lord, it has to be read in the circumstances. If it is not read the way, if it read in the way, my lord, my learned friend wants it to be read, that will give a power to the authorities that go on charging the fixed charges.
Person who does not who to pay the bills itself, liability is being
To go on
Need
adding
for
the
nothing.
fixed charges. A person is not able to give, and 4 years, assuming he's not able to pay. The 4 years fixed charges will be more than the amount which is, and the other hand, disconnection, temporary disconnection is already there. But the temporary disconnection is already there. Can such an interpretation be given to a provision of the act where the power of disconnection, temporary disconnection has already been done?
check.
I look. Fresh, he has to take a
This
fresh.
will not go, you have to come for a fresh
Yes,
connection.
that is the only difference. So,
Charge is not levied.
well,
Because
temporary
it is already
disconnection,
disconnected.
temporary discussion, a particular time is there, assuming or you issue the notice. Once you issue the notice for 15 days, and thereafter you don't disconnect on the ground that he says that I will make the payment and go on charging the fixed charges. In my humble submission, that interpretation is given, although 6 months is not there, my lord, but 15 days notice is there. After giving 15 days, once you issue the 15 days notice, don't issue the 15 days notice, very correct. But if you issue the 15 days notice, thereafter, you cannot say that I will not disconnect also permanently, but I will go on charging the fixed charges because you have said that please give me some time. My humble submission, if this interpretation is given, then it may be putting below the double burden. Person who is not able to pay the earlier charges, outstanding charges, and the period expired, you have given 15 days notice to him also that if you don't pay, it will be disconnected. Then it cannot be said that the consent, where it was a consent, my lord, that I will pay the fixed charges. There is no
Don't
consent.
disconnect is
There is no language that I will pay the fixed charges.
where is that request for
Just only that, please, we have
by the earlier person?
Yes. There was one request on.
Something.
First request was on 26/3/2014 at page 213.
213. No?
There were 3 more requests after that.
Yes, yes, I
You have the second letter 215. He has not only consented to pay the bill, that is after 6 months, he has also deposited a check of 1 crore.
yes, yes. Bills. the check and dishonor, there is a more defaulter.
Predecessor was definitely willing.
So my predecessor, once you say that my liabilities are there also, on the other hand, you are also saying my predecessor did. Both sides, it cannot be there. Either you say that my predecessor did, so he's liable, whatever he did. On the one hand, you are saying that you are liable for the predecessor. On the other hand, again, you are saying that the predecessor did. Whatever predecessor did and whatever liabilities are there, the present petitioner is liable. There is no dispute about it. I'm not disputing that at all.
How do we draw the line?
No, my submission is 6 months. But after issuance of the notice, 15 days notice if you are issuing, and thereafter if you don't disconnect on any request made, but in my humble submission, a harmonious construction of the clause of the clause not empower them to levy fixed charges after issuance of the 15 days notice, the expiry of the period of 15. And this will be also, if it is read in the light of the 92 and the 2017, intention will become clear. What is the intention? Time limit of 6 months was there in the fixed charges, that more than 6 months you cannot levy. 92. 2017, it has been made 6 months plus 15 days notice period. 6 months plus 15 days notice period, not beyond that. So if the present 2007 is read in the light of 92 and 2017, then a harmonious construction which has to be given is that after issuance of the notice and after expiry of the 15 days period, for that you cannot levy the fixed charges. 2.
Is notice.
But only 6 months.
2007 provide
Notice, so there's a 6 months plus
in
15
this
days.
to a settlement, it is days plus 6 months. 1992 said
6 months. 6 months. Please, 15 days notice period they have added. So both the cases, my lord, the 6 months, 15 days notice they have added because you are giving a time of 15 days. So 180 days plus 15 days, 195 days, which the ombudsman has taken it to be. Now, when any, my lord, as you also aware, when a provision is interpreted, then the previous law and subsequent law are taken into consideration. Intent and whatever was there cannot be said by any stage of imagination that it empowers the authorities to have a arbitrary power, levy the fixed charges for whatever time it comes, till they decide to finally disconnect on the either request or somebody else. It has to be a particular period, a reasonable period. And that reasonable period was prescribed in 1992 and 2017.
what are the
But I am asking for up to 6 months
they have charged you for?
or till disconnection, permanent disconnection. Plus 8 months.
8 months is in dispute now.
8
Whether
months in
that
dispute.
8 months is required or not, that is one.
That is a dispute. 6 months, 15 days, I am ready to pay. This 195 days, whatever ombudsman has said, I am ready to pay. Till the expiry of the 15 days period, I am ready to pay. Up to the expiry of 15 days period. That consumption bill, there is no dispute. I agree, my lord. Only dispute is.
Percent part,
Hello?
3% part, the surcharge
My lord,
part.
that is, and that your lordship will consider. That earlier I have shown to your lordship the clause. My lord, apparently it doesn't fall.
Person from LT to H.
Was there ST when I was ST earlier also, and subsequently also ST is only there. The provision was not there. This was noticed by the audit, and they observed it that it is not there. Thereafter, they came up with an amendment in 2017.
List. It is there. Provision of a surcharge is not there.
My lord, my lord.
That is causing loss. So please introduce a surcharge.
Absolutely, my lord. In
That
fact,
is what was done.
That
Prior to that, the provision of a
debate was there, surcharge was not there.
argument.
Now, taking into consideration the audit report, the 17th amendment was made. Amendment was made for imposition of the surcharge also. And 2018, they have raised the bills. They were also very much aware that the provision is not there and they cannot impose it. Otherwise, in 2016, audit was there. They could have imposed in 17 itself. Oh, my lord, and you'll also hear, my lord, unless and until there is a specific provision, levy of surcharge, penalty, interest, or any tax or duty, or duty, surcharge, penalty cannot be imposed. Must strictly fall in the provisions of the Act. It cannot be by way of analogy that somebody is imposing a surcharge, because surcharge is what? Is a nature of penalty. The present case. Anything which you are imposing on a person concerned, it must strictly fall in the provision itself. Now, as you also is also aware, although it is not in taxing statute, that if there is ambiguity, the benefit must go to the taxpayer. Now, here there is no ambiguity at all. They have taken it to LT. Where is the LT? I am not LT. When I am high tension.
We are speaking out our minds. Find out if you have an answer.
No, Lordship, what?
In the bills itself, and that is not disputed at all, nowhere. If my learned friend can place a single paper before Lordship. 130
was HT.
Page 128, my lord. The agreement. And you'll also may see page 133. Clause 9. Service connection. ST. And not only one bills, in all bills it is ST. Not a steel industry, rolling mill, etc., cannot run on LT mill. Power which is required can never be LT. And nowhere it has been said, and perhaps it cannot be said, that it was LT. It cannot be said. And in fact, I appreciate my learned friend. As a lawyer, my lord, sometimes the instructions and consents. Lawyer's consents is not allowing. But instructions are there. And my learned friend correctly said that only basis of instructions I am saying, because his consents was not allowing that this clause covers. It doesn't cover.
For everybody, the person who is supposed to pay up arrears, even they paid up till now, they will have to pay.
I'm
up the
simply asking
surcharge.
question to you, myself, my lord. In 2015 up to 3 cases have been cleared and have been paid, no dispute. That they have raised any bill, additional bill to them.
Yeah.
Because it's pending. Lord, that pays. In fact, it has been quoted also the relevant part.
The page number, it starts at page number 228.
228.
228.
Yes.
That is suggestion. that electricity board is getting the losses, but you are not charging surcharge.
Observation came at page
My lord.
per consumer. Therefore, they tried to
And this particular consumer, my lord, your lordship may kindly appreciate, my lord, how the audit only can be one particular person. The law can be there.
There are two. There is another one also on the next page. I still.
But the law which is there apply to everybody. And in 2017, the amendment which they made for imposing the surcharge,
Surcharge to some extent we
was 2017, otherwise the 17 amendment was not required. So they came up with an amendment.
is that amendment? What does it
2017?
exactly say?
Hello, your lordship, kindly. I just give my lord. Is
Yes, your lord.
Case supplies made to a
Yes, your lordship. This is the provision. Yes, your lord.
has come in 2017. My lord. My lord.
If we are unable to provide him, then he'll be given a rebate. Basically, it means for supply at voltages higher than is applicable to the consumers, a rebate of 3%. Oh, yes, yes.
we are giving it
If we cannot lower it down to his requirement, then
it. And in case a supply is made to a consumer lower than the specified.
lower than the specified, then a surcharge.
Where now the LT and ST is not there.
The metering is
My lord.
the case is not there. It
For supply of voltages higher than the
will 2007.
No.
The metering is not on the LT side. That is
It was at that point it was not there.
when in 2017
No, it will
the
apply.
metering is not on the LT side.
No, it's an or, your lordship. Or, not an and. So either of the two conditions can be met. The first condition, if the supply is made to the consumer at a voltage lower than the specified in
Or-
clause
or it is
2.21,
developed.
or is there. Perhaps in these facts and circumstances, the first condition is met, but at that point,
The
it is
2017 throws light on the 2007. 17 throws light on the 2007 that this was not there. When something had been incorporated in 2017, my lord, then the interpretation which is to be given, the something was not there which in 2007 has been incorporated in 2017.
Percent we have
There are two issues only, my lord, 2000 charges and the fixed charges. Fixed charges, your lordship will interpret the provision. 17,
one has tried to
intention behind. and a harmonious and reasonable interpretation which should be given, that it cannot be, a blanket power cannot be there, that a charge can be charged for indefinite period. My lord, so far as the first point is concerned, my learned friend has himself is agreed. Fixed charges, my lord, your lordship will interpret. And after the whatever is there, the bill they may prepare, and the person concerned pay the amount and the connection may be given. No temporary connection we have not taken because the court said 75 lakhs you pay. Now the 75 lakhs is only for 15 days. Again, for 15 days, you pay 75 lakhs. So it cannot be.
Whatever is to be paid,
Whatever is
go.
outstanding, other than the surcharge and fixed charges as your lordship decides, whatever amount is.
You to do so.
My lord. So that order, your lordship find. IA. Main petition, lord. My petition. I will pass over the order copy. That's why, my lord, I'm running on the generator for last so many 2 years or so. Paying near about 20 lakhs now per month. They informed us that it is only for 18 days. 5 lakhs will be over. Whatever the charges are there, the actual charges you have to pay again. Whatever charges are there. Amounting to penalizing, my lord, that it is impossible. Perhaps the court has not taken into consideration the fact.
As per the tariff code. Yeah.
Lord, in fact, the court was intended, in fact, that 75 lakhs
75
you
lakhs.
pay and connection may be given. Pay. But the interpretation which they have given that no, under the code, it is temporary connection is for 18 days only. So 75 lakhs you pay, 18 days is over. Again temporary connection, again 75 lakhs. Now instead of all those things, my lord, your lordship decides whatever finally, my lord.
One quick point, your lordship. Wise exercise for the orders passed by the CGR merged with the order passed by the ombudsman. Matter of fact is, lordship, the ombudsman has proceeded on a wrong understanding of the legal position. Not disputed that he has applied the 1992 supply code and the 8 order when the 2007 supply code was holding the field. On that ground itself, the order deserves to go as far as this issue is concerned. Now, if the argument advanced regarding harmonious construction tested, then your lordship, if your lordship comes to a conclusion that % surcharge was not present in the 2017. Similarly, that limit of 6 months was also not there in the 2007 supply code and was only added in 2017. So to apply that retrospectively, when the clear legislative intent is otherwise, if they had to give a limit of 6 months, they would have done so. There is no whisper that beyond 6 months you cannot do this. Not in the Act also, your lordship. Since this Act rules are framed under the Electricity Act, the Electricity Act also does not prescribe a limit that the temporary disconnection can be only for 6 months. Here there was a agreement between two parties. The party said extend, and so we extended. In fact, the definition of fixed charge itself is that it is not a charge on the consumption, but because of that, that entire setup that is required to supply electricity to a premises, only on permanent disconnection we take away everything.
That permanently has it been taken away from these premises?
Now it has been. On the date of permanent disconnection, with effect from 30/10/2014, then it has been removed. So till then we are saying till that 30/10/2014, you have to pay the fixed charge because your predecessor asked us they do not remove it. And the definition of fixed charge is that it is a charge on not on the consumption, but on the paraphernalia, which is required to supply electricity. That is there in the supply code. Since that is not there, to add that 6-month limit in the supply code, perhaps your lordship may not like to, your lordship.
Said that 6 months, I'm not saying about 6 months. Saying after expiry of the,
Yes, now.
just a
yes,
minute.
very well.
I'm 6 months period, I'm not saying at all. I'm saying after the expiry of the 15 days. Now, since the notice was issued after 6 months in the present case, that's why I'm saying 6 months plus 15 days. I'm not saying that 6 months plus 15 days. No. I am saying after the expiry of the 15 days notice period, whatever may be there.
The notice of 15 days was given.
If they would have issued me
There
notice
is no
after,
issue of 16. If you had given that notice,
after 8 months,
his argument is if you had given the notice after 9 months,
Yes.
then
9
it would
months
have been 9 months plus
plus 15 days.
So lordship will kindly have that provision for once again. 4.3.1.1, the relevant provision of that 2007 supply code. The word may and the commas are very critical here, your lordship. Because the
would have something in you perpetuity.
my understanding is that this is in perpetuity. Why? Because your lordship will see where a person neglects.
The provision of law allows it in perpetuity.
Yes, it does.
To keep it in perpetuity.
Because that has not been challenged by anybody here, lordship. The supply code, if it was under challenge, either before the ombudsman or before the CGRF or before a lordship here in these proceedings, then I would have defended it, your lordship. But since it has fallen for interpretation, I am just placing where a person neglects to pay any charge for electricity or any other sum due to him, due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him. So there is a requirement of a neglect or a failure. The licensee may. So this is the discretion. Comma. So the word after comma is not a discretion. That is mandatory. After giving not less than 15 clear days notice in writing and without prejudice to his rights to recover such charge or other sum by suit. The second comma. So this part is discretionary. The part starting after the comma after may and ending with the comma after suit. That part is mandatory. The licensee may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or such sum by suit, comma. So that part is discretionary. Cut off supply of electricity until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting the supply are paid, but no longer. Then the word after comma together with any expense, cut off supply of electricity, that is where the discretion again comes back. So the issuance of that notice is mandatory. So today I can issue that notice, but I may decide not to disconnect. Since that 6 months period or that 15-day period also, your lordship, there is nowhere does it say that it can. Very well.
Is notice. Thereafter, if you
I am bound to disconnect that connection unless he pays it.
up the 15th that due to your you have some staff shortage, if you have some other difficulty and you have not disconnected it, that will not be cast upon the consumer. That is the argument. I'm not saying accepted, not accepted. I'm saying that is the argument that you may disconnect it, you may not disconnect it. But the liability to pay will be up to the 15th day. Because thereafter, it is your choice. And an authority will not be left with a choice which has no limits or no boundary. That is the argument. Where the choice will end, and on
in an
If you
ideal,
decide to give a notice after 2 years, it is 2 years plus 15 days. If 10 days, it is only 25 days.
it cannot be 2
That
years, your
choice you
lordship,
have.
because there is a requirement under section 56 that we have to show the amount as recoverable.
Example,
So,
An
what-
example, I'm giving an example.
So,
Not 6, make it 9 months. Make it 1.5 months. Whichever way, whenever you give that notice, pay from the notice. You have a choice of when to give the notice. That choice you would have, subject to other provisions, but not a choice to.
the requirement of issuance of a notice, your lordship, comes from section 50 Electricity Act. So no person can be, the electricity cannot be disconnected before giving him a notice for payment. Notice. That principal section does not lay down any time limits. Here it says the right to disconnect is with the authority as far as this provision is concerned, not the ones in the previous enactments, not the ones in the future enactments. This provision. Right to disconnect is with the authority. What this provision says that once you decide to exercise that right, that now I'm going to disconnect, then you have to give him a notice of 15 days. Now, for example, if take your lordship's example, that for 2 years he has not paid. Before the expiry period of 2 years, we draw up a bill. We are saying you have not paid your electricity bill for 2 years. We are giving you 15 days notice. And within 15 days, if you do not pay, we may disconnect. The language of this provision is that it's not mandatory. We may disconnect. And within that 15 days, you not only have to pay your electricity charges, but also other charges which have been incurred by the licensee in connecting and disconnecting your supply. That is also the second part of the provision. So when the principal section under the Electricity Act and the rules framed thereunder do not prescribe any time limit, your lordship, because at the end of the day, your lordship, it is also a commercial relationship between two parties. So
To temporarily.
We have not supplied him, he has not consumed
The
electricity.
only liability that will remain of charges
Fixed charge.
because there is no supply.
There is no supply.
Issue is still when does he continue to pay the? Your stand is their stand is that once you tell me that you are going to permanent, is you are supposed to go the thereafter whether you disconnect
or not. That is the solution. Yes, your lordship.
Just try to explain.
Deeply obliged, your lordship. Deeply obliged.
Evaluate, but we will keep this not for anything else. If we to ask for anything to Thursday, we'll try to have the order delivered.
Act also, you lost your mind. Were there, where there was no time limit. Geo motor revision, there was no time limit. Does not mean that key unfettered power that whenever you want, you can do it. No. Must be a reasonable period. And reasonable period has to be gathered from the scheme of the act. Now,
Situation had come in with to the CRPF Act, where the power of a suo motu was not, the time limit was not there. Application for revision is reasonable is 1 month.
here I am saying, you know, reasonableness has to be gathered from 1992 and 2017 and determine what is the reasonable period. And my learned friend correctly said that once they decide to disconnect, they will issue a notice. So you have decided to disconnect and you issued a notice. Thereafter, you don't disconnect. It's up to them.
Section 56 of the act will be relevant, your lordship.
56 will not amend.
No, because this provision was framed, your lordship, in furtherance of 56. 6 says of the Electricity Act.
must be given.
Yes.
But we are-
15 days note, the 15 days notice comes from this provision. Very well.
আমাকে দিলে synopsis type, my lord, that
Thursday we are getting it listed again.
Very well.
not. These are the two short points, my lord, and that's why I'm not giving your lordship the retrospective judgments and all those things. Necessary, why to burden retrospective law, because they are not imposing, they are saying we are not applying 2017, so the retrospective law not be anything will. Or see, once I can give the judgments. Twenty-two.
And 49 of 20.
I'll prepare in
I'm highly obliged.
deeply obliged.
Retaining this for the time being.
Very well, your lordship. Very well.
এইকেইটাই ইয়াৰ লগত Yes, additional affidavit. Any reply to be filed? No.
Already file additional affidavit. Already file additional affidavit.
To this honorable court's direction, the affidavit has. In fact, Malot, your lordship, on other day that page 107, paragraph Malot 5. How they mislead the honorable court, Malot. That the SPO JD, right, later dated 30. A2 to the is 81 of additional affidavit said that follows, yes, it was done. However, the penalist advocate of did not submit any document as well as any document here in that regard in the office. More surprisingly, same authority in his letter dated 29/7/2024 at Annexa A79, Yellow says kindly look into those pages. How they mislead the honorable court. Page 79, Annexa A1, there is a document by 29 July 2024, one assistant engineer, Syed Mohammed Mohsin of the JDA, wrote to the petitioner this information at serial number 6 not allotted. Now, page 81, 82, serial number 6, yes, it was done. However, the penalist advocate of the said period did not submit any document as well as any document prepared in this regard in the office. That means contrary view, my lord. Now, India affidavit, the additional affidavit, is, my lord, 114 also, my lord, paragraph 6, next page, my lord. Their contention is
Are you
One-
saying that the yes part is correct or the no part is correct? Which part is correct?
Correct, my lord. Why I am saying it?
Yes part is correct.
My lord,
Now,
because
if the
it was
yes part
allotted.
is,
My lord, they again try to mislead it. They try says one Ruby Devi prepared the draft copy of the lease agreement. But they are saying that that lady was but Annexa E, she was D panel. My lord, on query, since these were happening, my lord, petitioner asks that by telephonically asks that Ruby Devi advocate that from that Ruby Devi, it is come to knowledge of the petitioner that prepared a deed, lease deed, and subsequently it is informed to the petitioner as well as that information derived from the documents, certain cash book and other documents from the JD has already provided to us. From there, it is reflected one Sanjeev Borwa. My lord, kindly note, my lord, there is a check number is there. White check number 506092. An amount of 4,10,000 rupees against that head, my lord, that said was allotted to the Sanjeev Borwa. Why they are trying to, my lord, play, my lord, misleading this honorable court, my lord, I don't know, my lord.
certain information.
Malad once said, yes, said Malad, teen said Malad. Oh.
I think
Malad,
page
in read
22
petition is clearly mentioned, Annexa A, page 23. English version is the.
You are not agreed with the
Not provided
other
to me,
part,
Malad.
only for
Malad, certain information pursuant to
information
this
number
honorable
6.
court direction, I was
Copy
provided.
of
But
lease agreement conducted for leasing of
Malad,
by
Malad, SPOI office.
what is SPO?
Rural Development Malad, Authorities Office, Malad. So in this regard, they.
So you wanted a copy of the lease agreement.
Malad. They says that, Malad. Not allotted, but
Then another authority,
well, same authority, same
same
person.
authority after some time tells you or what?
2 days, most probably 2 days. Malad.
You that yes. Where is that? Where's that letter?
Malad, page 81, Malad.
Page
82.
81.
That,
Development Authority.
got it? Yes, it was done.
Now, now development was done. Question and answer. Of the lease agreement. Right.
Side of the SPOI office.
নেকি তথ্য দিব no not allotted
Then 2 days later, Malad, 2 days later,
allotted but the panelists of you are appealing for whom? Please 5 and 6. Was it allotted or not allotted? You say that this page 81 is wrong.
Page 81 wrong.
Page 81 is wrong.
Yes, because he is not disputed on that.
If page 81 is wrong, any steps taken?
Not allotted, Miss Lordship.
Has given two information. No, not allotted. And
Not
the second information is yes, but we don't have any documents to support us. He has given a wrong information. Either one is wrong. One of them is wrong. What is it?
The language of SIP, the SIPO is like that. We was agreement with North with us, so so therefore we are not allotted to the seat to the person. The basic one. Agreement is not
in
with
the
us.
first, in the first guy, you are saying that the ব্যৱসায়িক গুদাম হিচাপে ব্যৱহাৰ কৰিবলৈ লিজ এগ্ৰিমেণ্ট কৰা হৈছে নেকি?
অসম RFP ব্যৱসায়িক গুদাম হিচাপে, so it is not allotted. Gudaam hisabe, it is not allotted to anyone. And lease agreement is done, but subsequently due to the panelist failure, it has not been finalized. It is the main thing. Gudaam is not allotted. It's done. Not executed.
Lease agreement was prepared.
Prepared but not executed. Neither furnished document, the panelist advocate during the said period, neither furnished any document nor any document was submitted which is prepared. Yes. Affidavit has been.
Where is the first affidavit that you have filed?
Annex is a page 79. Page 79 is a same annexer, but one is a type copy and it the vernacular one. Same thing will be because Gudam is not allotted to anyone. So therefore it is said no, not allotted. And agreement is not done, not executed due to the panelist of she has not submit the one. The lease agreement. This is only the case of the Gudam. So Gudam is not.
Gudam was not allotted is
Not
the
allotted.
first answer.
Yes.
And in the second letter, you are saying
Panelist is not executed the lease agreement.
It was done. Well, understanding, yes, it was done. In Assamese first person also page 81. Allot kora hoisil.
হৈছিল কোনটো কৰা হৈছিল?
Now, Malot,
কৰা হৈছিল নে লিজ এগ্ৰিমেণ্ট কৰা হৈছিল?
Malot, in the written affidavit, that is page 114, they try to again justify their.
Question asked is agreement.
Malot, that my
Noted
Malot,
and lease agreement.
Malot, I asked
Allotment not there.
petitioner.
Allotment not there.
Malot,
Yes.
Agreement prepared,
Malot.
not given to us by the panelist advocate.
114.
I put a question to that advocate also.
Where is it?
That is
statement-
recently after going to the affidavit of their affidavit, I asked the question. She says that yet I prepared it. Malad, no document is there, but I prepared it. I justify it, Malad. No document is there, but it was Malad allotted in the checkbook they provided.
It is an.
Your option, if Malad, I can bring it to the knowledge of court by way of additional checkbook against a particular amount, Malad was allotted to Mr. Sanjeev Borwa.
So how
The
can
check
he say?
number is there.
A round question was asked.
Malad.
Where answer has come up. Questions had been divided into two parts.
Malad.
Has it been allotted? No. Is there a lease agreement? No. Or yes. Something could have been answered.
Yes.
Abonton
yes.
oblique lease agreement or for a lease agreement.
my lord.
None. And then trying to the relief this court can give. Ask him to say yes or no. No,
Because,
What
this
is the
information
relief?
recently I obtained.
What is the relief, sir?
Belief is that, yes,
He should say.
they have misled this code. I'll justify the case book that's provided to me. In the case book, this particular check number, my lord, against 4,10,000 is my lord, given by one Sanjeev Barua. That means Sanjeev Barua, it was allotted to Sanjeev Barua.
So this is all a matter of facts. Let them
Matter of fact,
pardon of,
it's a-
it is
it's
a
a
pardon
document
of
is there.
2001. Let
Would you
him
like to
be
bring on
before the
record
trial
My
court.
lord.
the
And
My lord,
specifics
I can bring it
and
by one
specifically
additional
mention
affidavit.
that this agreement was done on behalf of my friend says,
And
the amount has been said, because as per in our page 114, but specifically says, numerous occasions we have request to the plaintiff's advocate submit the agreement, but he's used to submit. And husband on earlier occasion with a coordinate base of this honorable court in
Allowed to- I will
number
be allowed to-
133.
allowed to file, bring it by one affidavit, that on record, everything will be clear, my lords. Not, my lord, not to that effect, my lord. The document, case book, the Gujarat Development Authority provided me, against that, the check number so and so is, my lord, issued by one Sanjeev Barua. My lord, that is dear, my lord. I will annex this, that document for your case book.
permitted to bring on record
My lord.
is to have been executed. How much time?
2 weeks, my lord. Week date so that the yellow says.
I filed. By Hmm? Is so and so.
Could it be
Is this matter? What is this matter? Yes.
Pleading is, otherwise lordship, pleading is complete. If your lordships try to Lordship, on last occasion, they prayed for filing an additional.
No, already filed and that is.
If
in
it
the
is filed
record.
on 1/11 the copy.
If it, Lordship, I have received.
Thursday. This at the request of the learned matter on
This Thursday, Lordship.
on 20. To fix. Yes, sir.
My husband purchased a vehicle, Lordship, goods carrier. Sold. Thereafter, Lordship, the 28/03/2023 expired. My husband expired. Thereafter, I applied for in the official portal website, Vahan Citizen Service Alert, and wherein it was indicated that the vehicle is flagged as not to be transacted due to Patan Bazar PS case number 319 of 2023. Lordship, now, if I may take your Lordship to
The violation.
Lordship, violation is there. One private respondent number 5 made a complaint for the officer in charge, Patan Bazar PS, that Patan Bazar PS, Lordship, stating that she has lended money to the husband of the petitioner and he did not return, and thereafter checks were issued which were bounced. But she made a complaint before the police station, and accordingly, a case was registered under section 294, 325, 354 IPC. Now, if I take your Lordship to page 21, I may take your Lordship to page 21. 21, page 21, annexure 3. Down below, Lordship, vehicle flagged as not to be transacted due to reason police case under section 154 CRPC, District Kamrup, PS Patan Bazar, year 2023, FIR number 319, dated so and so so and so. After Lordship, the in charge Patan Bazar, PS Central Police District, Guwahati District, Assam, complaint by Srimati Kavita Devi, that is respondent number 8, not be given to in case of any discrepancy, kindly contact your RTO. Now, Lordship, thereafter, she filed that private respondent number filed an application before the DTO Baksa at page 25 on 29/2/2024. Like to state that Srimati Kavita Devi, wife of so and so, Puchi PS Gambari, I was in a business partnership with late commercial. I had invested 8 lakhs at the time of purchase of the vehicle for business, being the following details. So and so details were given. Now, last line, Lordship, last paragraph. It is hereby pleaded that till the dispute is resolved, the transfer of the ownership of the vehicle is not done without my consent. Thereafter, Lordship, I filed a application before the DTO Baksa at page 27. At page 27, Lordship got it. Page 27, this is the letter application I have written to the DTO Baksa.
You say?
I'm appealing for the.
Lordship, one thing. There is a circular issued by the Ministry of Road Transport and
We
Highways.
have seen the circular, yes.
Lordship.
My lord, in this case, it has been blacklisted because there is police case, my lord. That basis we have blacklisted it. Then remanded back, both the parties can be then called by the.
Who? Government. The party, yes.
I'm not appearing, A. Borua is appearing, he has been instructed to take adjournment to table. Even I can take consent on morning. But he is some difficulty to table. He's suffering from on the next week. Or as per the date.
Thursday lordship then.
Otherwise,
Just tell us that
my lord,
I had acted correctly.
it is true, my lord.
We acted correctly when it application. This is of 2023.
My lord, my lord.
Is it?
2024, my lord. It has been practiced. 24, it has
Yes,
been practiced.
Being allowed to transfer it and use.
My lord, my lord,
This act cannot.
it is, your, my lord is correct, my lord. I would suggest, my lord, let the parties then be called to the DTO office, then they can, my lord. Can be remanded back, my lord.
Power to do it, you. Why? Because someone has told.
My lord, my lord. And my lord, they provided me a copy. Fire also, and the
You
complaint.
can show the authority. Has been deprived of the right of. Is there any pending?
No, no suit.
I have been informed, my lord, there might be, it might be present, my lord. They're not aware of it, my lord.
The
5 minutes.
next.
Thursday lordship can it be on Thursday because she is suffering without any. 27.
Suffer from February.
Every day she is visiting the chamber lordship. Every day, almost. Oblige lordship.
28th, my lord. 28th.
But can it be on 29th?
9th.
29 is the Saturday.
We were fixing it on the 2nd of December.
2nd of December, yes. Correct, my lord. My lord is correct.
The compensation by British lordship. National Highway lordship.
Uncontested, sir.
Lordship is not entitled for getting the compensation for land as because it's a government land.
If it.
Lordship, yeah, that instruction we have.
Instruction has come.
Lordship come.
Instruction has been received. And the affidavit would be filed. See? Along with the affidavit proposed to be filed by the respondents. Yes.
Senior.
Lordship, in the last occasion, the respondent saw time file an affidavit, but till date.
Instructions awaited, kindly. Last opportunity.
Death has occurred. It was issued in November 2024.
Let my senior come, he is on.
Yes, how much time? Respondents have not. Is this matter again in? Weeks from today.
Notice is
Why?
because, my lord, initially, my lord, he was not made party by name, my lord. Accordingly, I felt and was implemented by name, my lord. Been issued the response number 9.
Was passed in a connected. Allowed to be made a party respondent by. Council paying for the respondents, so by as well as by then number 9, other respondents paying the.
Obliged.
This case regarding the sale permission, they have filed application that was not sent. Their allegation is that that was not yet been sent to the nodal officer. Accordingly, we have been directed to obtain instructions why it was not sent. We have received their instructions, Lordship. It was already sent to the state nodal officer, so now they will be able
Yes,
to.
madam.
So after receiving Commissioner, then take a
Who has to take the decision?
Again, in that case, again, we have to take this instruction.
the Peru's page.
No, on the facts, you have reverted back to the deputy commissioner. Reverted back.
Then revert.
Along with your opinion or no? Along with your opinion of the concerned officer. I've heard Mr. S. Page number 20. And has been reverted. Six. The notification.
In 9/2000.
So please this matter again. They should be fixed by the registry. Update this code with regard to.
Matter relates to restoration of revenue board.
Restoration of.
Was cancelled, that has been directed to be restored by the revenue. Upheld the judgment passed by the revenue board. There is no problem for.
Yes.
File your affidavit, Lordship, in this matter. Lordship.
After.
Heard. Can full stop. It is noticed that 2025 full stop. File their affidavit. You are required to respond to the repetition. No.
Accommodation, today our file is not come lost.
There was filed challenging a tender condition. However, there are some developments we have been rejected again, which will of action firstly. Secondly, the affidavit is also been
Received a copy of the affidavit.
My lord, Handloom and Textile.
him to go through the, or to respond to the affidavit in opposition, full stop. Please again.
My pleasure, Lordship. Lordship, this is a ventilation of the custard. But it issued the custard present petitioner, Lordship. Lordship, while ordered it at 90, chairman of the state level issued has a cast certificate of present petitioner. Direction the issue to the district commissioner to direct the present petitioner to surrender his cast certificate. That is the case, Lordship. But while passing that order by the chairman of the state, Lordship.
Will you call for that hearing?
No, Lordship.
You call for a
No,
hearing?
no, without affording any opportunity of hearing. That is the case, Lordship.
Okay.
A violation of the guidelines laid down by
That
Honorable Apex.
order,
Our Lordship, that order was not communicated with me, Lordship, but Lordship. Yes, Lordship. Lordship will find at page 16, Lordship. That is the communication issued by the Deputy District Commissioner. Sir A, Lordship.
appears for no response. Is the affidavit?
If we have received our instructions, short date may be given for filing our affidavit.
What about the records? They're here. Where?
Fair Lordship. That may be considered, Lordship. Impaired, Lordship. The operation of the impugn order as well as the communication issue. The college teacher.
Considered on the earlier occasion.
Yes, Lordship. Notice was on interim, Lordship. I am the college teacher, Lordship. There was a hearing in the office of the DHC, Lordship, on the authority.
Mr. B.K. Gogol.
BCA. On behalf of Harem Das Social Justice. Harem Das.
Or you are appearing in this matter? On 5 and 6. Okay. On. Keeping the learned council.
Social
Justice and empowerment has submitted that affidavit in opposition period of 2 weeks in the month of full stop, that no coercive action be taken.
Obliged, Lordship.
Yes.
I may appeal, Lordship. Private respondent file if another.
9 and 10 applied.
4, 3, 4, 5. 4, 5, 6 yet to be filed affidavit. That is not case. As per section 11, my lord, absolute authority, my lord. President and vice president. Here in this case, my lord, petitioners are the board members and respondent number 4, other private respondent.
No, no. I'm, my lord, I'll like to file.
Sir,
What date, my lord? What date may be given, my lord? They are illegally enjoying the.
who is illegally
No,
enjoying?
no, Your Worship.
A private respondent, my lord,
It is
president, vice
elected-
president, my lord.
Elected member.
All
Can it
elected
be
men?
illegal?
They are not elected by the petitioners. They are the 4 persons, my lord, 4 ward
11th
members.
of December 20. 11th of December.
President and
President, vice president of the council.
Vice
Vice
president.
of the council.
Top
Sir.
Panchayat.
Directed to obtain instructions, the instruction awaited, Lordship.
Not received it.
Well,
Not
if-
received.
Why not received, Lordship?
Much time.
by court number
Saying what?
directed
Please.
to
60 also sent.
sent.
Provide him a copy also.
Lordship, Lordship has fixed it on Wednesday, both the cases.
No, 59th.
Lordship.
My lord.
Last Wednesday. Is covered, we cover.
Yes, Lordship.
May it please your lordship. My lord, in respect to supplementary list item number 61, my lord, I am appearing virtually for the petitioner.
Would have to wait. It is item.
Apologies, my lord, there is some technical issue. I am unable to hear. Apologies, my lord.
Wait, please, your Lordship. Your Lordship, last order, we were directed to take had a talk with the Lordship. Today I am seeking for the day.
And-
Your Lordship.
parties are no longer in office, they may be allowed to, my lord, serve give the order with
Please, lordship here.
stating to my lord that payment special family pension and ex gratia because was paramilitary, was kidnapped and killed.
Lordship.
Yes.
Lordship, in compliance of the court order, we have paid the ex gratia to the petitioner. I may submit this. Lord.
Has been paid.
But my lord, I have instruction, my lord, 4,50,000. We paid 5 lakh.
X.
Family pension.
Instruction. What?
One part was already given to him, then he subsequently placed the other lordship ex gratia. One part has been, I think that was.
Section is there, my lord.
The order, what is the order?
Page 12, my lord. Paragraph 10, page 12. 10 is the operative person.
Find out what family pension.
Family here, ex gratia,
Paid. We are not. And claim for payment of. Communication we will. Family pension part.
What's it by?
Page 12.
What's it?
What? The ex gratia.
Lordship, I'm for respondent number 3. Lordship. I'm appearing on behalf of Dinat R. Sahni, on appearing of Dinat.
$5 lakhs to the.
It is my lord 23,620.
If the
Special family pension.
put the
Not RSU.
oh,
Much.
I was looking at the earlier order, so that came out.
Please, your lordship. Earlier this morning,
You were required to take. Can we presume? List this matter again after. Amended cost title, no. By which time? Upon receiving shall be drawn by this court.
I am for the respondent number 6, Lord.
The is complete after
is a Lozima Court's order dated 26/9/20. Steps upon respondent number #21.
I am appearing for lordship respondent number 6 to 20.
just a minute, just a minute. F
Respondent number 6 to 20.
for 1 to 5, sir.
1.
And 5 full stop. Ah,
21 is the like daughter lordship. If my friend obtain instruction lordship, he can appear for 21 also. 21 lordship.
daughter is she?
Lordship, Salamuddin Borbhuya. For the other legal heir lordship, from 16 to 20, my lordship.
Have your instructions on the next certificate?
Yes, lordship. Deeply obliged.
4 weeks, 6 weeks.
Lord, in this case, respondent number 3 has filed an affidavit.
My lords, I'm appearing for the
So
response.
we have filed our reply today. Let it come along with the reply, my lord. Lordship.
APS
My
for
lords,
3.
I'm appearing for the respond number 3
3.
through VC. I'm appearing for the respond number 3 through VC.
I have got the affidavit number.
They have filed it.
They have filed it, and
My
today
lords.
the petitioners have filed the reply. I'm told.
Rejoinder, yes, my lords.
You have a copy
Yes.
of it?
I have received a copy
No,
of
we have handed over a copy to the local council.
just, yes, just some time ago today. So my lords,
Take it after.
Your Lordship, I have filed an application under section 17B of the Industrial Dispute
may
Act.
have some urgency, lordship may have it next week.
On Monday or Tuesday, any
Wednesday.
Wednesday.
my lords, I'm not able to hear.
No, no.
Again,
We've handed over. Yes, I,
next.
yes, not
next, on Tuesday.
next for the disposal
I'm
of my
sorry, my
IA
lord,
lordship.
I could not hear what my lords just pronounced.
You'll have the order after some time.
My lordship,
Highly
I'm
honored.
submitting that.
Again, on the third.
The next day
Go
is
on.
fixed for the disposal of my IA, which is I have filed under section 17B.
IA filed by the.
Uh, 4 and 5.
And 5 shall, from him.
Yes, my lords, I will take it from my local council. Highly honored. Thank you.
Steps upon the respondent number. Engage council member.
For whom?
For bank matter, one
The
to
bank.
6.
And
Numbers.
did a complaint to whom?
Complaint to the bank official.
The bank. Why don't you dispose it of? Oh, steps were taken. The post.
Before the registry.
Is for an accommodation to be. We'll establish the matter after a week.
After 4 weeks, my lord.
A date may be fixed.
4 weeks on by the registry. Order were given.
I did not.
Us at 4 o'clock we have.
Yes. Let it be after 7 days, my lord, in that case.
Some instructions, yes.
Refund has been made, my lord, probably. Probably refund has been made.
Beginning 8th, my lord. Otherwise,
9th of December. Tuesday.
however, yet to appear in the in steps and the affidavit to the last order, my lord.
The last order. Was it?
Of the last order, 10.
Otherwise, the server with the rest of the.
It has now become infructuous, I think. Yes, with the bank. There are 2 of the OTS letter, they have accepted that they will withdraw this writ petition, I think. They've already settled the issues by paying the total amount of 40 lakhs.
They find out.
In this case. Yes, your lordship, 1, 2.
2025.
Yes, not a scheme, your lords.
Up. Have instructions from the petitioner.
Published, my lord.
But it's a very old land acquisition for the national games which was held in 2004. This land was acquired. Thereafter, my lord, several litigations were instituted. And this honorable court passed orders that give us alternative land. My lord, now in terms of section 20 of the 13 Act, earlier proceeding lapse has to be done under the file these my lord, seeking a was issued long back, my lord. Lordship should have not filed any objections state. Lordship should amendment, my lord, and their affidavit I will file an amend, consolidated.
Not is appearing in this case.
There is nothing on.
Oh, they would
Yes.
file an amended writ petition.
Yeah, then they will file a
Which
reply.
still have the
Reply affidavit.
pending is.
It's true, my lord, but the notice. Yes. Just
Although it is too late in the day, let me just. There's no objection, we'll allow it.
Yes. No, there possibly there cannot be any objection.
I'd like to contest it on earlier pleadings. I do not know.
Or else they should, that's why we said, my lord, we retain our earlier prayer. They cannot provide us alternative land, then give us compensation. Because earlier proceeding has lapsed. Yes.
Proof of dusty, where is the petitioner?
They have filed petition.
Petition.
I'm for
My lord, I am appearing for the petitioner in this matter.
Have you
my-
filed?
My lord, the service has been conducted. However, the dusty we have just received, I have not filed the affidavit and put it on record, my lord. And the service has been done via registered post, my lord, in this matter. My lord, there is apologies, my lord. I cannot hear your lordship, my lord. There is a certain urgency from my end in this matter, my lord. My bank account has been freezed.
There are 4 respondents. 4.
If.
I am for the respondent number 3.
I'm
Punjab National Bank.
For respondent number? Is this matter again on third?
Apologies, my lord, for the interruption, but I am unable to hear you, lordship, my lord. My lord, I'm still unable to hear. If a short date may be fixed, my lord, I'll appear in person, my lord, before the honorable court, my lord.
When? Give us a
My
date.
lord, 27th, my lord, if it can be fixed on 27th.
Of the Learned Council for the
And deeply obliged, my lord.
My lord, some time, my lord. Instruction is awaited, my lord.
Regarding my lord, respondent number 6, my lord, there is a office note, my lord.
Two, my lord.
My lord, 2111, my lord. I did not return, my lord. Track status has been shown that it was delivered.
allowing the response.
It's after 2 weeks.
Huh? Yes, do you admit it?
Your lordship, I just saw it on the display board that our name was reflected. We were unaware that this matter was listed today.
On. To
Maybe
enable the
reflected in the cost list as well. Yeah.
I oblige.
It will, Your Lordship. Here petitioners,
don't go long, something short.
here petitioners, others.
We'll pray for some time. Much. Okay. A place for
Here I have no need to file reply. There.
they've given you the liberty, utilize it or don't. Yes.
I think instruction has been given only to record the objection. Verbally, I've objected it.
One second, my lord. 41. That 41C and 41D. Basically, paragraph 6, my lord. Paragraph 3, my lord, of the IA, as well as the cost title.
And
The cost title, my lord. And the prayer.
the position has been filed.
My My name can be Sonmalan.
Court has gone through objections raised by the learned. As reflected.
Paragraph 3 of the IML. Fair portion.
Up next, you take down in the
In 1 week, we'll file the Millard consolidated writ
to
petition.
file
In a week. April.